We're back. Yeah, no, that's fine. So if I could ask you just to go down, starting with X through double E, what each exhibit is and whether or not you object to each one, again, just to confirm for the record.
Okay, Chair Ben, would you like me to talk about what each document is or just?
Sorry?
Would you like me to confirm what each document is?
Yeah.
And the basis for the objection?
Yep.
Okay. Exhibit X is a copy of the Supreme Court decision in Larson v. Sinclair Transportation, which is the Colorado Supreme Court. The COGCC may take judicial notice of that document, but we object for relevancy. Exhibit Y is the extraction oil and gas Altman Z score. We object on authenticity, foundation, and relevancy on the fact that they proffered no witness for the entry of this exhibit into evidence. Mr. Larson, on behalf of L&L, is not an expert, an economic expert of any kind. Exhibit Z is the transcript of the final pre-hearing conference. No objection. Exhibit double A is the National Institute of Standards and Technology study. Again, no foundation, not authentic, and no expert, so it's also irrelevant. Exhibit BB is Extraction Oil and Gas SEC Quarterly Report. The COGCC may take judicial notice, but again, we think it's irrelevant and would object on that ground.
Say that's double B.
That's double B.
Object on basis of relevance.
That's correct.
Okay.
Double C is a map provided by L&L. We would object on authenticity as well as relevancy. It's not clear that Mr. Larson prepared this map or has any personal knowledge of the information therein. Exhibit double D is again, another map. We object on the same grounds. Exhibit double E is another map. We object on the same grounds. Exhibit double F is a wellbore assignment and bill of sale. Now we would object on the Mr. Larson has no personal knowledge of this document, although the COGCC may take it as a matter of public record. It's also irrelevant.
Okay, again, so I can make sure that I have the record. Exhibit X, you object based on relevance. Exhibit Y, you object based on authenticity. Exhibit Z, you have no objection. Exhibit double A, you object based on relevance. Double B, again, object based on relevance. Double C, double D, double E, which are all maps. Relevance, object on the basis of relevance and authenticity for all three of those. And double F is a wellbore assignment and bill of sale. Object on that based on relevance. However, since it's a matter of public record, it could be included.
That's correct.
All right. Very well. A moment, please.
Chair Benton, may I have a chance to respond on a few of those items?
Just a moment. Very well. Please go ahead.
Okay. As far as X, it seems as though that Colorado Supreme Court case, they objected on relevancy, but it goes to the specific trespass issue that's underlying this, some of the issues here as potentially a grounds for that. And we asked that the commission would take judicial notice of that and include it in the record. Exhibit Y, which is the Altman Z score, Mr. Larson can talk to his knowledge about that document, and we would request that the commission allow him to do so. Exhibit Z, no problem. Exhibit A, Mr. Larson is a professional engineer licensed in the state of Colorado and uses these NIST standards in building. And we would ask that the commission allow him to speak shortly about what his knowledge is to input that into the record. Exhibit BB, which is the Form 10Q, goes to the financial wherewithal and reasonableness of the lease, whether or not extraction is a financially stable company to lease for. So I think it goes directly to the pooling application here on a reasonable offer or lease. It is a matter of public knowledge. We ask that the court or the commission include that in. Exhibit C, C, D, D, and E, Mr. Larson has been involved in the creation of these, and would ask that the commission allow him to speak on his knowledge of those before a ruling is made on the admission of those. And then Exhibit FF, Mr. Larson specifically identified that document as something that he studied when in his capacity as president of L&L Inc. It's a matter of public record, and the commission can certainly give it its weight that it wants, but we believe it's relevant and should be included in. So we would ask that that the Exhibit X, which is the Supreme Court case, Exhibit Z, sorry, Your Honor. Exhibit BB being entered as a matter of judicial notice as a public record, as well as FF, and then let Mr. Larson talk about some of these other items briefly.
A moment. Okay. Well, Mr. Larson, we'll give you a couple of minutes to speak on the ones that you think need to be included.
May I?
Yes, Commissioner.
Before we move to that, it seems to me from looking at the materials that are in our hearing portfolio that exhibits X, Y, Z, AA, and BB were already included as appendices to the Larson's supplemental pre-hearing statement. So it seems to me that those were not objected to at that point. They're already in the record. With regard to CC, DD, EE, and FF, I would politely propose that we allow those in, recognizing that they would be coming in as appendices to a Rule 510 statement and are not strictly to be considered as evidence by us, and that we then move forward to give them the appropriate weight as we render a decision in this matter, just in the interest of, partially in the interest of time.
I think we'll go for a fairly short period of time. I think it's, and obviously not being an attorney on this, I'm concerned about admitting them as part of a 510 statement when we've already had a party object on the basis of relevance. So I'd like to hear what Mr. Larson has to say. And then I think, and you rightly pointed out, and I apologize for forgetting that those other exhibits are already in our attachments. So I think we'll just leave them go in. Yes, sorry.
Those supplement exhibits we did object to based on foundation authenticity as it relates to those additional exhibits in the pre-hearing statement. So we did not stipulate to those admissions, but given it's a 510 statement, we have no objection with the process that you have proposed.
Which is to keep X through BB, leave them in there.
As it relates to a 510 statement and give them the appropriate weight, that is fine in the interest of time.
Okay, and then what about CC through FF?
That's the same.
Same?
Yeah.
Very well, then you don't need to speak. We'll go ahead and include them as part of the 510 statement, since you've removed your objection. All right. In that respect, I think you've finished. Thank you very much. Oh, I already asked. They said they had no cross-examination. So thank you for coming in today. Which means you can go back and sit in the audience. So commissioners, extraction is here today, make sure they don't mess this up, with the hearing officer, essentially with a pooling application. They've submitted a plethora of evidence that was supplied to us ahead of time. I've managed to get through a fair amount of that. And so I really don't know if we need to hear a presentation. I'm okay with just going to questions, but I want to know what the rest of the commissioners have to say. No presentation? Very well. I'll ask each one. Commissioner Hager, are you okay with just going to Q&A? Commissioner Overturf?
Yes.
Commissioner Jolly?
Yes.
Commissioner Hawkins? Very well. Do you have any questions for extraction with respect to this matter? Or for that matter, a question from the hearing officer. I think you've reiterated your recommendation that we approve this. So
I guess I have a question.
come on, somebody ask a question. Commissioner Hager.
I would ask extraction about the potential Kerr-McGee lease at 25%. What comments you have on that and whether or not it was excluded and why it shouldn't be considered in the our assessment of whether or not it's a reasonable offer.
Good afternoon, Commissioners. Jason Rayburn. Sorry.
Do we just swear him in?
Probably should. I mean, you've been sworn in before, but let's go ahead and make sure that you're going to tell us the truth again today.
Yeah.
So would you please stand? Raise your right hand, state your name, and say that you swear to tell the truth.
Jason Rayburn. I swear to tell the truth.
Thank you.
The lease between Kerr-McGee and I believe it's Anadarko Land Corporation. From my experience, Kerr-McGee takes every lease that they have mineral interest in at 25%. Our analysis that you were presented with was based on Extraction's own leasehold in terms of bonus, royalty, term, actual knowledge of those leases, because we cannot have any information outside of what's in the record, in the county records. So that was not included for that reason. As far as the sale of the Kerr-McGee interest, I was not a party to that transaction, so I can't speak to the details that go beyond what the document says that's in the record.
Can you comment on whether 25% is a common offer without a bonus requirement?
No, it is not common. Again, the only pattern that I've seen with a 25% interest is Kerr-McGee leasing between their own entities, essentially to themselves, on minerals that they own in the basin at 25%. But I have not taken a lease at 25% in my career. I've not done that.
All right, thank you.
So when you acquired that lease through that assignment and bill of sale, you essentially picked up that 25% just came across?
Again, I don't have the full knowledge of the details behind that transaction, but I can tell you what can happen. Because Kerr-McGee is the mineral owner, they have the ability to alter that royalty as respect to the wellbore sale. So whether or not and again, we did not purchase that lease, we only purchased Kerr-McGee's interest in those wells, specifically named on that document. But I would say that there may be other factors working there that I'm not aware of.
Okay. Go ahead, Commissioner Jolly.
Well, we're talking about 25% leases. What about the Frank and Arlene Wind? Is that not one of your leases?
Yes, just 1 second. Let me grab my exhibit on that.
Control C to copy.
Yeah.
No, the source is.
Question.
How do I paste it? Yeah, are we talking?
Oh, yeah.
It's a little.
So the wind lease that you're referring to has other factors, again, working along with that deal. For instance, the surface use agreement that we have in place with the winds. Also, let's see, this lease was taken in 2013, before my time, so I don't have any personal knowledge of taking this lease. Let's see. Also, this lease is quite far from the lands that we are discussing today.
Like how far? More than a mile?
I believe it's. So it's in 568, section 31. The lands that we are discussing today are section 13 of 469. So we're well over 6 to 8 miles away from the lands that we're discussing today.
I thought this was closer. Okay.
There was a lot of talk today about wells, status of wells. Can you help, because it looks like on the state information, the wells have been completed. Can you help clarify that?
Right, so
Curiosity.
I think we use completed in different forms. So completed in terms of the information that's available on the Colorado Oil and Gas Commission website means that the well bores have been completely drilled and cemented. But, and I have personal knowledge of this, the wells listed on our dockets today have not been fracked. And so they are not completed in that sense. That we typically say they've been completed. They've not been fracked. They've been completely drilled and cemented.
Mr. Sparks.
Just for clarification on that, the wells we're talking about today they've been drilled, those wells have been drilled but not hydraulically fracked or completed, do not penetrate the Larson's mineral interest. There are wells that have been drilled that do penetrate the Larson's minerals, but
No,
these,
right. So
they've been drilled but not completed.
yes, right.
And
No
Google-
well that penetrates the Larson's minerals has been hydraulically fracked and is producing oil and gas.
Very well. Okay. Any other questions, commissioners? Way on Commissioner Overturf.
No, I'm good.
You're good?
I'm good.
All right. Are we prepared to entertain a motion here? Let's get more Commissioner Jolly.
I just have a question. What are the lease terms that were offered? I've seen several.
We made 5 lease offers over the past a little over a year. The first dating back to December 2017. They're there in your packet and also here on the screen. The bonuses range from $600 an acre to $3,000, with the royalty going up to 20%. The term on the 2 years was a discussion between us and the Larsons, and that's kind of how we landed at that term.
Commissioner Gibbs.
Thank you, Mr. Chairman. I'd like to make a motion that we move to accept the hearing officer's recommendations on extractions lease offer pursuant to Rule 530 and Colorado Revised Statute 34-60-116.
My second.
Okay, motion. Let me get some clarification on that. Is that a motion to approve the pooling? Because I think that's what it is, the pooling order. Okay, so a motion made by Mr. Gibbs to approve the pooling order as represented in the docket numbers listed earlier by Ms. Larson and seconded by Commissioner Ager. Any additional discussion? Hearing none, let's proceed with the vote. All in favor, say aye. Aye. Opposed, same sign.
Aye.
Motion carries.
Thank you,
We have
Commissioners.
one opposing. You opposed, right? Okay, all right. Thank you.
Thank you very much.
Thank you.
We'll take 5 minutes while everybody gets ready for the next one.
Yep.
And you opposed on the basis of? Just curious.
trying to give you two. Sorry.
I'm convinced that you own stock in a paper company somewhere.
I should.
We're just waiting for Commissioner Boygan to return. Ms. Larson, did we find him?
Yes, Mr. Davenport is letting him know that the meeting has started again, so.
Okay. Well, we will wait for him to return.
Thank you.
Ms. Larson, if you'd like to tee up the next docket number.
Certainly. So before you is docket number 1803-00184, Bonanza Creek Energy Operating Company, LLC, and Noble Energy, Inc. Each of the parties have 1 hour for their presentations, and that would include any closing statements and rebuttal. It does not include questions from the commission. And Hearing Officer Rouse will introduce the matter for you.
Very well. Now that Commissioner Boygan has returned, we can ask all the commissioners if there is any conflicts of interest with any of us with respect to this matter. Hearing none, Mr. Roush, would you like to proceed?
Thank you, Mr. Chairman. This hearing involves a relatively straightforward spacing application. Bonanza Creek Energy Operating Co. LLC seeks an order establishing a 1,280-acre drilling and spacing unit for the Niobrara and Codell formations and approval of 20 horizontal wells for sections 24 and 25, Township 5 North, Range 63 West, 6th PM. The setbacks requested are 460 feet from the unit boundaries and 150 feet from any other well bore in the unit. The applicant requests no more than 4 multi-well pads, and all this is fairly standard for the GWA area. Noble protests because it has a better plan and it is the majority owner in the proposed unit. Noble claims that approval of the requested unit would create waste, allow for inefficient development, violate the mandates of the Oil and Gas Conservation Act, and adversely affect and aggrieve Noble's leasehold and the existing producing wells. Notably, there is no competing spacing unit or application before you this afternoon. Each party will have 1 hour to present its case. This includes opening, closing statements, direct and cross-examination, and rebuttal. The time limit does not include time for commissioner questions and answers to those questions. The order of presentation is as set out in the final pre-hearing order.
Thank you. Which we have now presented. Not certain that I don't believe there are any motions or any procedural matters in this case. Or any particular stipulations. So at this point, we can go on to the opening statements by Mr. Willis.
Commissioner,
Yes.
or Chair, if I could just
Yes,
for a moment, we did have a discussion with Noble with regards to expertise today, and we did reach a joint stipulation that all people testifying today, all witnesses, would be received by the commission as experts in their field.
Very well. Thank you for that stipulation. I appreciate that. And so now, Mr. Willis.
Thank you. I was panicked when I was listening on the webcast near 1 o'clock, and you had indicated that you were going to have a gap with regards to what was occurring on your docket today or your agenda today, and you were calling my case early. I'm comforted to have seen that you had plenty to fill your plate in that period of time, but I'll be more attentive to it in the future to make sure we've got individual shares so you don't have any kind of problem with gaps in what you're attempting to do. Bonanza Creek has filed a typical application seeking approval of its development plan for sections 24 and 25 of 5 North, 63 West. and requesting the commission to establish an approximately 1280 drilling and spacing unit for these lands with authority to drill 20 new horizontal wells within the unit for production from the Codell and Niobrara formations. The application lands are located in the Wattenberg field and within the greater Wattenberg area, which is a rule set out in your rule book. This area is a known and prolific source of supply of hydrocarbons from both the Codell and Niobrara formations. I've got 4 witnesses to present today. The first is Max Faith. He's land manager for Bonanza Creek. He's also seated next to me now. He'll explain his efforts in attempting to engage Noble, the majority leasehold owner with the application lands or within the application lands to discuss a joint and collaborative development plan for the acreage. However, his efforts were largely unanswered, reflecting little motivation for Noble to keep this now contested application outside of this hearing process. Bonanza Creek has ownership within the application lands. He'll describe where that ownership is, and he'll give flavor to how Bonanza Creek's development plan, which calls for standard reach 1-mile laterals, as well as extended reach 2-mile laterals, is consistent with other plans regularly approved by the commission. He'll further discuss Bonanza Creek's surface imprint and relationships with surface owners. He'll provide testimony regarding correlative rights and how all interest owners within the application lands will have those rights protected under an approved application. Jeffrey Schroeder, a development geologist for Bonanza Creek, will explain the geologic characteristics of the Codell and Niobrara formations underlying the entirety of the application lands. He'll explain the thickness of each formation and how those thicknesses support the development plan, which calls for Rule 318 influence setbacks of 460 from unit boundaries, and also interwell setbacks of not less than 150 feet from any treated interval of a new, from any new permitted horizontal well to a treated interval of any existing or drilling Codell and Niobrara well. Christina Burnett is a senior reservoir development engineer for Bonanza Creek. She'll testify regarding whether this project is valuable to Bonanza Creek and whether the approved application will lead to efficient and economic extraction of the resources while preventing waste and protecting correlative rights. Her team's technical evaluations on certain lands, including these application lands, significantly improve well performance. She'll describe her drainage calculations for the application lands for both the Codell and Niobrara formations, and ultimately give her opinion that the requested number of 20 new horizontal wells within the unit area is a reasonable number, resulting in the drilling of necessary wells, which prevent waste. Don Lima is the Director of Subsurface and Development for Bonanza Creek. She'll be my last witness. She'll provide expert testimony regarding Bonanza Creek's regional development plan, which includes these application lands. She'll describe Bonanza Creek's infrastructure and the capabilities in the vicinity of these application lands and how those facilities protect public health, safety, welfare, and the environment. I thank you in advance for entertaining this conversation today, and we'll certainly pass it now over to Ms. Jost.
Go ahead, please, Ms. Jost.
Thank you. If I may, before I start, Enrique, may I have the PowerPoint clicker?
Oh, I think I've got it here.
Oh, sorry. Thank you. Thank you. My apologies, but it's not working. There we go. All right, thank you. All right, thank you. Good afternoon, commissioners. My name is Jamie Jost, managing shareholder of Jost Energy Law, and I'm here today on behalf of Noble Energy, Inc. Thank you for allowing us to present this issue to you today, and we also want to extend a warm welcome to new Commissioner and Executive Director Gibbs and Director Robbins. Many of you are undoubtedly thinking, why are we here on what seems just like another operatorship issue? Why can't you both just figure this out on your own? In reality, Noble does not want to be here today and shares those same questions with you. But since forced to be here to protect its interests, Noble will make its position in this matter very clear. As to the first question, why are we here? Noble is here because Bonanza's application for a 1,280-acre unit does not comply with the mandates of the Oil and Gas Conservation Act, 3460-116-1, 2, or 4.
if approved, would allow for a violation of the Act's prohibition on waste, and any approval thereof will immediately harm Noble's 100% producing leasehold interest in Section 25 of the application lands, and its 75% leasehold interest in the entirety of the proposed unit. We are here because this is not the typical operator drilling and spacing unit fight you've seen recently. The lands are not virgin lands where no horizontal development has occurred. The lands are not lands where two operators have competing speculative future development plans. We're here because there is a legal and policy argument about the Commission utilizing its authority under the Act to mandate efficient development of the hydrocarbons within a unit, to prohibit waste, and to protect a majority interest owner from a minority interest owner's taking of hydrocarbons underlying a 100% productive developed leasehold. As to the second question, why couldn't you both just figure this out on your own? There's no resolution to be had between the parties when Bonanza's proposed development, if approved, would allow for the destruction of Noble's 3 producing wells on its 100% leasehold to the detriment of Noble and its 100% mineral interest owner. There's no resolution to be had when Bonanza's proposed development does not provide substantial evidence in compliance with the Act 3460-116-1, which is to prevent or assist in preventing waste, to avoid the drilling of unnecessary wells, and to protect correlative rights. To reference the Commission's own analogy used on many occasions, Bonanza has the burden of proving each leg of the 3-legged stool is intact. Here, the 3-legged stool that this Commission must rely upon has no legs. In addition to showing that the 3-legged stool has no legs, Bonanza Creek will also fail to provide evidence to illustrate that its proposed drilling and spacing unit will efficiently develop the hydrocarbons in a pool as required under 3460-116-2, and they will not be able to show that the number of wells proposed will result in the most efficient development, and in fact will result in unnecessary wells and will immediately create waste. Waste has many different aspects under the Act, and any approval of Bonanza's application will result in more than one type of waste. Noble will present testimony to show Bonanza's inefficient development will result in inefficient use of the reservoir, result in physical waste, will result in the spacing of wells that will reduce the quantity of oil and gas recoverable from the hydrocarbon pool, will have imprudent and improper operations, and will result in an abuse of Noble's correlative rights, as Bonanza will produce more than its equitable share from Noble's 100% leasehold interest in Section 25. As you will hear from Noble's witnesses, the proposed unit contains 1,280 acres where 100% of Section 25 is owned by Noble, 100% of the southeast quarter of Section 24 is owned by Noble, and approximately 35% of the northeast of Section 24 is owned by Noble. Noble's proposed development is a land and mineral grab, resulting in imprudent and improper development of Noble's leasehold interest, where Bonanza owns 0%. They own nothing. You will hear testimony that Bonanza is seeking to include 320 acres of drained minerals in this unit. Noble did not and could not have participated in the existing 320-acre development in the west half of Section 24 when Bonanza drilled it in 2014. And any inclusion of those minerals at this point in time in a larger unit would harm Noble's correlative rights. You will hear technical testimony about the immediate damage to Noble's 100% interest, its producing wells, and its leased acreage if this application is approved. And finally, you will hear testimony that Noble is relying on this commission to protect its existing economic development of its 100% lease and 100% ownership of 3 existing producing wells that have been producing since 2010 and 2012. Based upon the testimony Noble will present to you today, we would request that the commission deny Bonanza Creek's application. Thank you.
Thank you very much. Mr. Willis, would you like to proceed with your case in chief?
Thank you, Chair. I would. Could I ask the advisor to the board, Mr. Davenport, to swear all witnesses, just to expedite things?
That would be a great idea. Thank you for doing that.
Sure, I'd ask that all witnesses for both parties please stand. I'm going to start with the gentleman on my right in the back, and we'll just work to my left. If you would please just raise your right hand, state your name, and say that you swear to tell the truth. Please go ahead, sir.
Jeffrey Schrader, I swear to state the truth.
Don Lima, I swear to state the truth.
Thank you.
Maxwell Faith, I swear to tell the truth.
Tina Burnett, I swear to state the truth.
Thank you.
Brian Bolton, I swear to state the truth.
Ken Cooper, I swear to tell the truth.
Mike Marie, swear to tell the truth. Thank you.
Good afternoon, Mr. Faith. I'm going to direct this microphone over to you. What I'd like you to do is to first introduce yourself to the board or to the commission. Thank you, Enrique. Let them know what you do for Bonanza Creek. And then I'd like you to go through describing any exhibits that you used to demonstrate that the application should be approved today as presented by Bonanza Creek.
Yep. Thank you, commissioners, for allowing me to speak today. My name is Max Faith, and I'm the manager of the land department for Bonanza Creek Energy. I've held that position for 4 years and have a combined 15 years of total experience in the oil and gas land profession, and I am certified as a petroleum landman. So just to go through that.
Right. So what I put up here is Exhibit 1. Could you tell the board what this exhibit purports to be and how it's relevant to your testimony?
Yeah, this is just a very basic regional shot of where the lands lay in the DJ Basin. We're in 5 North, Range 63 West, sections 24 and 25, sitting just east of the town of Kersey, Colorado.
And this next exhibit, Exhibit 2, what is that?
This is a general land map of Bonanza Creek's oil and gas lease holdings with the application lands outlined in black dash.
What I'd like to do is now slip to the last. This is always a lot easier when I'm not in front of people. Great. Oh, I don't even know if that would help me. What I'll do is just pan forward until I get to the last one. What is this exhibit, and does it assist you in presenting your case to the commission this afternoon?
Yeah, what this slide shows here is a more localized view of Bonanza Creek's oil and gas leasehold in and around the application lands. The yellow signifying areas where Bonanza Creek has either full or partial interest in those lands. This area has been a very heavy focus of Bonanza Creek in our legacy development, dating back to the inception of the company. In this area here depicted, there are essentially 2 large landowners, one being the Colorado State Land Board, of which Bonanza Creek is one of the largest holders and producers of state land board minerals, the other being a very large ranch consolidated fee owner. Bonanza Creek has spent many years cultivating the relationship with the fee owner. It's largely outlined in these squares here, in which we have taken years and several versions of a very comprehensive SUA, surface use agreement, that covers thousands of acres and very carefully and deliberately sets forth the way we're going to develop it. Well pads, production facilities, oil, gas, water pipelines, roads are all set forth in advance and agreed to, predetermined sizes. So you can see we've been very deliberate in the way we go about developing this particular area in which the application lands are included. This includes very minimal surface disturbances as pipeline corridors follow the roads, cuts down on truck traffic, and all of which perfectly ties in with Bonanza Creek's regional midstream infrastructure. The 2 well pads we are expecting to use in this development plan are there in the yellow and the yellow square. The orange square is a central production facility, which we call our super section. Has, dozens and dozens of wells feeding into it. So you see the proximity to our infrastructure calls for almost no new installation of pipelines, very reduced truck traffic, and we think this is a responsible way to go about the development.
I'm going to move forward again to the last exhibit in our packet, and that's Exhibit 18. You heard Ms. Jost in her opening statement, which isn't evidence certainly, but it kind of encapsulates what Noble's theory or position in the case is. But do you have any reaction to her comment with regards to 100% ownership in Section 25, for example?
While we do own less acreage in the proposed unit than the protestant, I think what we have here is largely a case of optics. I should state that there is no codified rule that states a minimum working interest ownership in a proposed unit, and therefore I don't think the application should be denied on that basis alone. I think that the protestant is relying largely kind of on this visual and the polar kind of separation in our leasehold. And it's actually because of that we feel it is necessary, in fact, wasteful for us to try and develop our acreage without adjoining it to the adjacent acreage. We don't feel this is any sort of departure from any other drilling and spacing application that gets approved routinely on the consent dockets. And I don't think we are asking for anything exotic. And if this application were to approve, those lease lines would essentially be erased and the development can take place. And I think if the yellow and the white had a more, scattered or checkerboarded pattern, I don't think that Noble's response would be quite as impactful as they're hoping.
There's also maybe a discussion, maybe some evidence concerning a land grab. Do you have any reaction to that?
Yeah, it's not uncommon, certainly for operators to join their land and spacing units with, in some cases, dozens of other owners and operators. We try and take a proactive approach in reaching out to these folks before we do it. If in this instance, we are a minority owner. In this case, as you know, this application has been going on for the better part of a year. I think my initial attempts to reach out to Noble or after the application was filed in, I'm guessing, April of 2018. I did get one meeting with them that was largely fruitless. Other than that, any emails or phone calls were largely unanswered. So I think at this point we're at an impasse and we've kind of found ourselves here today. And in addressing the statements that that Noble has a better plan, well, if it's out there, we haven't seen that. We're not asking you to pick our plan over theirs. They have not submitted any APDs. We are simply asking you to approve our plan.
Let's talk about that a little bit. You talked about the APDs. The sticks on this particular exhibit, do those depict APDs which are currently in queue now for Bonanza?
They do. And I can't comment as exactly where in the process they are, but as far as I know, this approval of the spacing application is amongst the last steps. We're waiting for approval of those APDs.
And directing your attention to the west half of Section 24, that has a certain number of wells in it that are producing now. Is that right?
That's correct.
And those are Bonanza Creek wells?
Correct.
And what authority did you get to drill those wells? Were those under Rule 318A or under drilling and spacing unit? Or
I believe those are under wellbore specific units.
Thank you. Nothing. Oh, I'm sorry. Go ahead.
I was just going to add that I don't believe that the protestant has any real technical, whether it's geological or engineering, objection to our plan. I think they are simply playing the role of an obstructionist. I think they are simply claiming that the majority owner interest should prevail in this case, which we don't believe is proper grounds to dismiss the application. And just to summarize, as I said, our application calls for the utilization of existing well pads, existing below ground infrastructure. And we believe that this is the highest and best use for the land to extract the resource in a responsible manner. Bonanza Creek is a prudent and reasonable operator. Our application is consistent with the Oil and Gas Act. We are ready to take this plan on and ready now. If this application and subsequent APDs were approved, these wells would be drilled later in 2019. We don't feel that leaving the resources in the ground to be developed by Noble at some undetermined point in the future is beneficial for any of the stakeholders, whether it's royalty interest owners, surface owners, anyone except for Noble. And we feel that these issues have been decided this way in the past. We request that you approve our application consistent with the precedent of this commission.
One more question I have for you before I pass you over to Ms. Jost for cross-examination. With regards to any production taken out of Section 25 or any of the Noble lands in Section 24, is Bonanza Creek accountable for that production to Noble?
Yes, absolutely. If we would hope that they would, if approved, resume negotiations with us in terms of their involvement as a non-participating owner. They have the opportunity to invest and become an equitable owner in these wells to the tune of their working interest ownership.
Right. And these are in the GY area under Rule 318A. So it's possible that if they wanted to operate or drill their own wells, they could certainly do that under that rule. Is that true?
That's correct, yes.
All right. I have no further questions for Mr. Faith and would pass him over to Ms. Jost.
Mr. Faith, just a couple of questions.
Sure.
Can you please turn to your Exhibit 2? Thank you, Rob. That's okay.
Get out of here.
Perfect. Thank you. And if you could look at the notated join and spacing unit, isn't it true that Noble owns 100% interest in Section 25 in the white?
That's correct.
Okay. And isn't it true that Noble owns 100% in the southeast quarter of Section 24?
That's correct.
Okay. And isn't it true that your reference to 100% leasehold Bonanza Creek of the northeast quarter, Bonanza does not have 100% of that quarter section?
That I don't know about. I would have to double check that, but it's certainly possible. Yeah. And if that map is in error, then we can fix that for sure.
Okay. Thank you. And then there were several other exhibits submitted as part of the packet and the PowerPoint. One of the exhibits, which is your Exhibit 6, states that it is obvious that application lands do not have a high priority for development of Noble like they do Bonanza Creek. Exhibit 6 states that, correct?
Correct.
Okay. And do you have personal insight into Noble's continued development plans for their 100% interest in Section 25?
I don't.
Okay.
No.
And do you have personal insight into Noble's Mustang CDP or your proposed unit or their proposed unit development within the CDP?
I have seen what has been filed and approved publicly with this commission as it relates to the CDP.
Okay. So you can't claim as part of your exhibits that you know Noble's plan of development for its already producing 100% interest in Section 25, correct?
I cannot, but I think with a reasonable degree of certainty for the amount of effort they put forth towards that CDP, I think it's a fair to assert that that's where their efforts are going to be concentrated for the upcoming years. And to my knowledge, they haven't been active anywhere near the application lands in several years. So that was the basis for that.
Okay, great. Thank you, Mr. Faith. No further questions.
Welcome.
No further questions for Mr. Faith. I'd like to move along to Jeffrey Schroeder.
Commissioners, we can go a couple different ways here. We can ask questions as we go along. As long as there's not too many, so we can just keep this flowing. So we'll start that. If not, then we'll just hold them to the end. So Commissioner Jolly, go ahead.
Thank you. Mr. Davis, you said that you had reached out to Noble. Is that in the form of a joint operating agreement or trying to buy them, or And you were somewhat rebuffed.
Yeah, we have tried to purchase the interest from them. That has been denied several times, which, if they don't want to sell their assets, that's fine. In terms of joint operating agreement, I think we would do that at some point. I just don't think we're far enough into that process. These wells wouldn't get proposed for several months. But we would certainly go down that route when the time comes.
You mentioned that you've gone to great lengths to acquire a relationship with a certain landowner.
Correct.
Unnamed. Is he on board with you drilling? I mean, is he going to benefit from this, or is he in the drilling area?
In terms of a mineral ownership, is that
Yes.
the question?
Or surface?
Yeah, they have approved the drilling. They've approved all the, I don't recall the rule, but whatever surface owner consultation is required to submit the permits. They have done that. As I stated, we have a very large comprehensive surface use agreement with them that sets all that out. And in terms of mineral ownership, I know they do own partial minerals underneath their ranch. Whether or not it's this exact application area, I don't know off the top of my head.
I didn't see any like 5 to 10 statements or indication that there were mineral owners that were anxious for you to come in. Can you address that?
We didn't reach out to any. I don't recall who the actual royalty owners are under our leasehold. I believe, if I'm not mistaken, the mineral owners under the Noble lands is Anadarko or Kerr-McGee. So I think it can be probably surmised that they would like to see the development, but we didn't reach out to them as part of these proceedings.
And I don't know if this is a question for you or not, but I'll throw it out as counsel or Noble's saying they'll lose $67,000 a month in current revenue from leaseholds or from existing wells. Is that disputable?
I don't know if we
shut their existing wells in.
Yeah, and I think that's something.
Permanently, or
I'm sorry.
Permanently or temporarily, the existing wells they have on there.
Yeah, and I think my colleagues would address the anti-collision.
Thank you.
So I'm not the right person to address that.
Very well. Shall we proceed?
It's fine.
Okay.
Oh, I'm sorry.
Oh, sorry, Commissioner Hawkins.
Looking at this exhibit that you've got 2 surface locations that you're proposing for development. And let me just ask you, the wells that are in purple and on the east, or excuse me, the west half of 24, those wells are all producing under wellbore spacing units?
Yes.
Would they
Yes, sir.
share production with the entire spacing unit?
The leases under those wells? Yeah. Yes, they would.
So the wells that are currently drilled would get shared to Noble?
No. The application, Commissioner Hawkins, calls
Definitely.
for new horizontal wells, basically, and that any existing wells be unaltered by this overlay of a 1280, which is done all over the basin. This type of exercise is used. So we're not looking to alter the payout structures for those four wells, which are under the wellbore spacing unit.
Will there be any more wells drilled in that west half of 24 to the northern, up to the north?
I think it's possible. I think we would leave that option open.
But all the wells that are drilled to the south from that west half location are almost 100% Noble Energy lands, but they're only going to get 62.5% or something like that of the working interest.
Well, I don't. This is approved. The working interest would be uniform across the spacing units.
But their interest in the spacing unit would be what?
Well, I think the number that's been thrown out is roughly 75%.
75%?
Yes.
All right, so half of those wells are going to be pretty much 100% their minerals, but they get 75%.
As for in terms of the investment in the well, is that what you're asking?
Well, I know that they're paying 75% of the investment and they're getting 75% of the production, but it's basically coming from their 100% leases.
For those wells in that western pad going
The western
south?
pad.
Yes.
And then on the eastern pad, they do have about 75% of that, of the wells that are actually going to penetrate those lands, and they pay 75%. So that doesn't look too bad, but the wells on the western half doesn't look too good.
Right. But as a result of the spacing and subsequent pooling, that would all kind of get blended together.
The only reason I'm saying that is that you're including all of Bonanza Creek lands on the western half of 24 as part of the spacing unit, but there's not any new development proposed up there.
Yeah, and I would, in terms of maybe why that is, I would defer to some of my colleagues. I think there's probably a hurdle in terms of an economic or geologic reason why those weren't planned, and so I'll defer to my colleagues on the answer for that. I think if it was possible for those wells to go in on this occupation, they would have.
I think that's true, Commissioner Hawkins. I think we'll address that in a portion of our case.
Okay.
Thank you.
Thank you.
Please go ahead.
Thank you. Mr. Schroeder. Good afternoon, Mr. Schroeder. Could you give your name to the commissioners and let them know what you do for Bonanza Creek Energy?
Good afternoon. My name is Jeff Schrader. I'm a development geologist at Bonanza Creek. I have a Master of Science degree in geology, 10 years of oil and gas industry experience, 5 of which have been spent working the DJ asset for Bonanza Creek.
Now, you had prepared several exhibits of which didn't work their way fully onto the slideshow that I put together, but I did you did present these in a packet to the commissioners so they could see those as well. Did you use these exhibits to formulate an opinion as to whether or not hydrocarbons exist under section 24 and 25 of the lands at issue?
Correct.
And is this consistent with your analysis throughout the greater Wattenberg area? Can you say whether or not the Codell and Niobrara formations exist and whether or not they are common sources of supply of hydrocarbon?
Yes, absolutely.
All right. And you also assisted in looking and preparing this exhibit, Exhibit 18. Could you describe to the commissioners the development plan that Bonanza Creek has as it relates to what your occupation is at Bonanza Creek?
Yes. One of my primary roles is to provide the geologic inputs to a multidisciplinary technical team who sees all of our projects through from concept to execution. During the conception phase, our team performs a very rigorous analysis of the reservoir properties in the proposed development area that are derived from open hole logs that we've calibrated to lab analyzed core samples. And these properties include, but are not limited to, porosity, permeability, oil and water saturations, hydrocarbon maturity. And now in the area of the application lands, we used over 24 open hole logs that cover the Niobrara and Codell to use in our analysis and calculate resource in place with high confidence. This provides one of the key inputs that Christina Burnett will discuss momentarily. Then in order to safely and efficiently plan the execution of these wells, we as a development team collaborate with our drilling and completion team to plan the wellbores and optimize our completion design. This also includes a detailed review of all existing wellbores in the area to ensure we eliminate any drilling hazards, reduce any frac 2 impacts, and ensure we're compliant with all the latest rules and regulations. Now, in the case of existing wells in the application lands, We will design our well bores to adhere to the requirement that the productive interval of the new wells be no closer than 150 feet from the producing interval of the existing wells. To date, we have drilled and stimulated approximately 30 horizontal well bores that cross existing horizontal well bores of opposing geometry with negligible impact to those wells.
And I think that's in response generally to a question that I heard from one of the commissioners, and that's whether or not there might be some, or it might even been Ms. Joe's comments to, as she opened up her case, but there are existing wells which are in section 25, which transact what your development grid is. Is that right?
Yes.
All right. And so do you have any level of confidence that you're able, or have you during the course of your working at Bonanza Creek been involved with similar types of projects where you might transact these types of horizontal wells?
Yes, like I said, we have done this with 30 other well bores. I can actually point out this would work.
It does.
Okay, so we just stimulated these wells here, and you can kind of see there's a diagonal well there. It belongs to Bonanza Creek, and so we have high confidence that we can execute on that plan with no risk.
All right, and so is there any permanent damage or anything like that to those wells which are going to be impacted by a different development orientation?
I'll defer to our engineers that
right.
can speak to that better than I can.
Okay.
I do believe they have plans to discuss that and technologies that are in place these days to mitigate.
Okay, and you also heard Commissioner Jolly talk about his concerns for the west half of Section 24. Do you have any response for any of his questions, or would you like to defer that over to part of the technical team?
I'll generally defer that. That's some engineering work that will be discussed. It's sort of the resources there. It's just the calculations that they'll discuss that go into the economics of whether or not that's appropriate at this time in commodity price.
I have no further comments or questions from Mr. Schrader, and I'd like to pass him to Ms. Jost for cross-examination.
I'm gonna move my sign over.
Please go ahead, Ms. Jost.
Thank you. Just one question, Mr. Schrader. When you were looking at your Exhibit 18, I believe the well bore you pointed out was, I'm sorry, in Section 28 over here that you said you traversed, correct?
Yes.
And that was a Bonanza Creek well bore, correct?
Yes.
It was not a well bore of another operator?
Correct.
Okay, thank you. No further questions.
Do the commissioners have any questions for Mr. Schrader?
It doesn't appear to be, so perhaps you'd like to move on.
I would.
Thank you for your time.
Christina Burnett.
It's quite all right. I'm going to save mine for the end. Yes.
Ms. Burnett, good afternoon. Could you give your name to the commissioners and also describe what you do at Bonanza Creek Energy?
Hello, my name is Christina Burnett, and I currently work at Bonanza Creek as a senior reservoir development engineer. I'm a graduate from the University of Wyoming, and I have a bachelor's of science in chemical engineering, and I'm a certified professional engineer in the state of Colorado in petroleum engineering.
All right, and did you prepare any exhibits that the commissioners might have looked at or considered in advance of today, which address drainage calculations or engineering economics for the application lands?
Yes, I did. I prepared several. I prepared 2 exhibits addressing drainage calculations, both for the Niobrara and Codell formations. I've also included an exhibit that essentially extrapolates those calculations from a standard reach 1 mile lateral to an extended reach 2 mile lateral. And then there's also some economic exhibits that have been included. One exhibit that was included with the original submission of this application roughly a year ago. And then a second exhibit that we have added that includes economics based on our updated type curves, which take into account our enhanced well completions.
All right, so kind of lead the commissioners through your exhibits if you don't mind, or if you wanted to maybe even talk about, maybe before you get down too deep into the tables, you might want to talk about what your analytical technical team is involved with at Bonanza Creek.
Sure. So I've worked at Bonanza Creek for almost 5 years. And in that period of time, I've been intimately involved in basically our evolution of understanding in terms of well completions, well spacing, and drawdown optimization. So my current work is specifically focused on data analytics and integrating those analytics into our development workflow to allow us to make the best economic decisions and ultimately add the most economic value to the company. So these technical evaluations of both our acreage position and surrounding acreage positions have allowed us to significantly improve our well performance over time. And you'll see, especially in the past 2 years since we resumed drilling and completions activity, those drastic improvements in well results. These improvements have been so prolific that third-party data analytics companies have actually put Bonanza Creek on par with Noble in terms of normalized oil EUR performance in the past 2 years. And this is due to, we feel, our enhanced completions and what we call enhanced recovery flowback, which is essentially our drawdown management of our reservoir pressure. So to walk you through some of these exhibits, basically as part of the evaluation of this contested acreage, I performed drainage calculations for both the Niobrara and Codell, which can be found in Exhibit 13 and 14 of my submitted testimony. Based on these drainage calculations, it's my belief that Bonanza has requested a reasonable well count per this 1280 DSU. And I've also, like I mentioned, calculated economics for both a standard reach and extended reach lateral based on our enhanced completions, updated type curves. It is my belief that based on this evaluation, the development of this contested acreage utilizing our enhanced completions will be economic in the current price environment. I feel that Bonanza Creek is equipped to economically and efficiently develop this acreage position due to our rigorous approach and detailed understanding of this asset. We have requested a reasonable well count for this 1280 DSU, and we believe this development will be economic in the current pricing environment. We are a respectable operator, and we are prepared to economically develop this acreage position in 2019.
Commissioner Hawkins talked about the development in the west half of Section 24 and why now there are no contemplated. I'm going to switch over to slide 18. This one, and why there are no planned aqua well bores in that land right now. Do you have a response for him?
So as you can see in this exhibit, there's 4 horizontals clearly outlined in this section, but what is difficult to see is there's actually 2 additional Codells that are stacked beneath our Niobrara B wells. So coupling our 6 existing horizontals with the high density existing vertical development, we feel that in this current price environment, it was not economic to add additional well bores to this basically 320 acreage block.
And I talked to Mr. Faith about this a little bit, but those wells that are producing in the west half, those are Rule 318A wellbore spacing unit wells. Is that right?
Correct.
All right. And is it possible, or is it something you can predict in the future as to whether or not additional wells might be drilled within that west half of 24?
It's certainly commodity price driven, so that's not anything that we can comment on this time because we don't know how commodity prices will change in the future.
There's also been discussion about concerns surrounding the Noble wells in Section 25. Do you have any expert opinion as to whether or not you can complete your wells under an approved application successfully, or whether or not you'll damage or impact negatively those existing Noble wells?
So in my 10 years of experience, I worked the DJ Basin for almost 7, both as a reservoir engineer and as a production engineer. And so on the production engineering side, I've seen a lot of wells that have been, fracked into by offsetting child well completions. And it's hard to say definitively what the response of a parent well will be in that situation. Sometimes wells come back stronger than before. Sometimes they're damaged. So it's not possible for me to comment specifically how these wells will respond, but it's also not fair to say that they will be completely unproducible either, because there's just mixed results that can be seen across the basin in those types of scenarios.
Commissioner Jolly had a question to Mr. Faith regarding something. Of course, it escapes me now. Do you recall a question that Commissioner Jolly had? Or Commissioner Jolly, could you restate the
Mr.
question?
Jolly, would you like to restate that question, please?
Sure, I think the question was in the Noble response, they said that they would suffer damages of $67,000 a month from the impact from these wells.
So the answer to that would be along the same lines of my comments on fracked intos. I don't think that Noble can say definitively what the response of those wells will be once they're fracked into, and would not be able to give a concrete estimate of damages with any level of certainty, because wells respond to being fracked into differently, depending on a variety of things.
I don't have any further items that I'd like to draw for Ms. Burnett. So if Ms. Jost has any cross-examination.
Yeah, we want to do cross first, Commissioner Boygan, and then Q&A, because I have a few on this one as well. Yes, Ms. Jost.
Okay. Just one quick question. And by the way, congratulations on University of Wyoming. I'm a Cowboy as well. So,
folks.
So very quickly, based on your testimony that the parent well results are variable when you have wells that are crossing, traversing, or fracking into them, this could also mean that Noble's wells won't come back at all, correct?
It's a possibility, but we can't say that definitively.
Okay, thank you. No further questions.
Commissioner Boygan.
Thank you, Mr. Chair. Actually, that's where I wanted to go as well, and I wasn't sure if you were the correct witness, or maybe that Ms. Lima would be the right witness to talk about the impacts on Noble's wells. You've just conceded that the Noble wells will be fracked into. And so I'd like to hear more testimony from both Bonanza Creek and Noble on that issue, on the extent of that and whether it's avoidable and what the impact will be. And I also want to hear somebody, I'm not sure again if you're the right witness, talk about from an engineering standpoint how you're going to traverse those Noble laterals. Are you going to sail in over them, under them? What are you going to do? And what's going to be the potential interference and other potential engineering impacts of doing that. So I don't know, again, if you're the right witness, you can talk about that. Otherwise, we can wait for Ms. Lima.
Do you have any response to Commissioner Boygan's questions?
So we would honor certainly the 150-foot setback. And again, I would just like to say that wells certainly respond to being fracked into differently. And in some cases, being fracked into, I mean, we've seen it actually help offsetting well performance. That's not always the case. But to say that, Noble would specifically lose that revenue stream, that can't be said with any amount of certainty. That's what I believe to be true.
Have you looked at production from these Noble wells?
I have. I've looked at production that's available publicly on the COGCC website. And these wells are of older vintage, certainly 2011, 2012 wells. And so they have minimal production currently. But the last data that was available publicly was, I believe, October of 2018.
So is it your testimony that, in fact, those wells may benefit from being fracked into?
It's possible that, again, wells respond differently to being fracked into. So no one can say definitively how wells will respond.
Okay. Commissioner Boygan also talked about the drilling program in itself and whether or not you're able to thread your way through these wells. I guess that kind of takes you into a 3D world. Is that right? Could you have any response for him in that regard?
I'm probably not the correct person to answer that question, but I'd defer to one of my colleagues.
Is there anything else, Commissioner Boygan, that she might have missed that she might be able to testify to? I think Ms. Lima will testify with regards to your concern about how the wells are going to be threaded.
No, I'm happy to wait.
All right.
All right. if I may. So the intent would be, I heard, the intent was that you're going to try at least to stay 150 feet away from those well bores, wherever whatever bench the Niobrara or Codell they happen to be completed in.
Yeah, we would honor the 150-foot setback.
All right. Are you aware of any regional studies where folks have, and this becomes a bit of a challenge because these wells are older, whether or not there's been any regional studies done on these where you have this sort of crossing occurring as to where statistically they fall as far as wells that have benefited from, been detrimentally affected from, or no change?
So specifically at Bonanza, I would say no, we have not looked at any regional studies necessarily determining frac into impact. I can speak to a well that Bonanza Creek recently, it was the same situation, was a diagonal well in which we traversed with multiple horizontals, 10 in fact, and the well has actually come back into production and is stronger than it was previously. So there are certainly examples of that happening as well.
And lost my train of thought for that one. Probably come back to it. So you mentioned something about the difference between enhanced completions and sort of your standard one. Can you elaborate on what's different between enhanced completions and original ones, or is there someone else that needs to do that?
No, I'd be happy to speak to that. That's actually been a major focus of my work since I've been at Bonanza Creek. So essentially when Bonanza Creek was drilling and completing wells up to 2015, we were drilling and completing with sliding sleeve completions, wide stage spacing, and low fluid and proppant loadings. And what we're calling our enhanced completions are all cemented plug and perf laterals with tighter stage spacing, tighter cluster spacing, limited entry, and higher fluid and proppant loadings on the order of double what we were pumping before.
Okay. And I remember what I was going to ask you, because it seems to imply that anytime we cross an existing well, that the well get fracked into. Is there any cases where that has not occurred that you're aware of?
No, not that I'm aware of. No cases where it has not occurred.
So we can be fairly certain that they will get frack hits.
Certainly the likelihood of a well being fracked into is dependent on distance. I mean, we have seen those correlations in work that we've done at Bonanza. So, it is dependent on distance, so.
And just anecdotally, it's interesting, and one of the very early things that came in front of this commission 7 or 8 years ago was about this, and it was inconclusive. There were some wells that improved and some didn't see any effect at all as a result of that, and some probably saw some reduction in production. So
I would say it's still inconclusive. Yeah,
still inconclusive.
That remains consistent.
Yep. Thank you very much.
Thank you.
Oh, can
Yes,
I just have one further question from Ms. Burnett, I think, in reaction to what you just talked about, I think, Commissioner Benton. And that's do you have any concerns as to whether or not resource would be wasted if this application is not approved by the commissioners?
Absolutely. I mean, specifically looking at section 25 with only 3 existing horizontal wells. And again, they're of an older vintage, of an older completion style, much like what Bonanza used to pump with sliding sleeves and wide stage spacing. Those wells were certainly understimulated, and there's certainly a resource that is left behind currently in section 25 that would not be captured unless those wells were traversed with new horizontals.
Sorry, Mr. Willis, now you made me think of something else. So you've looked at those wells in a fair amount of detail. Do you have kind of sort of a range of their estimated ultimate recovery and their remaining recoverable reserves?
So we haven't performed recovery calculations on those wells specifically, but certainly just looking at recovery factors across the basin within the Niobrara Formation specifically, they're quite low. And so there's certainly reserves left in the ground in section 25, and there will be if that area is not developed.
Thank you.
Thank you, Christina.
Thank you.
I'd like to finish up with Don Lima. Good afternoon, Ms. Lima. Could you give your name to the commissioners and let them know what you do at Bonanza Creek?
So good afternoon. My name is Dawn Lima, and I'm currently the Director of Subsurface and Development at Bonanza Creek.
Are you aware, or are you familiar with the application that's been filed by Bonanza Creek with regards to section 24 and 25?
I am.
All right. And do you have any opinions as an engineer as to whether or not that would be an appropriate way to develop these lands? And do you have and then provide a basis for that?
So I do. As an engineer, I always have an opinion. So I've been working in oil and gas for the past 20 years. I grew up in Canada. I went to the Royal Military College in Canada. I'm an Air Force officer. My discipline at school was as an aerospace engineer. I studied chemical and materials engineering and quickly found oil and gas. And I've spent over 20 years hopping around the world in oil and gas. Being in the US for the last 14 years, I'm now a citizen of the US, and I've spent the last 6 years at Bonanza Creek studying engineering with Christina and development aspects of our acreage with Jeff, all aspects, and developing a comprehensive plan of development for our acreage, which includes these application lands. As it states in the Oil and Gas Conservation Act, it's declared to be in the public interest. Bonanza Creek's plan of development for the 70 ranch area is a balanced development that eliminates waste and protects both public health and the environment. Our plan uses existing frac locations, which are already approved by a landowner that we have a surface use agreement with in place. And as Max mentioned, we've worked for years to develop a relationship with this landowner. We work with this landowner on a daily basis as we develop the ranch, his ranch. We will reuse, our production will refill existing pipelines, and our production will refill an existing centralized facility. This facility was designed and built to meet Colorado's air regulations. And we at Bonanza Creek, we're very proud of our EH&S stewardship in Colorado. Bonanza Creek is the current operator and the current producer of the acreage around the application lands. It's obvious from the exhibits on the map that we are active in this acreage. And if our plan that's being proposed today is approved, we will use centralized facilities, we will use consolidated well pads, we'll use consolidated production sites, and we already have the pipeline infrastructure developed. And our plan significantly mitigates the environmental impact and the surface impact. We have been the sole operator in these lands for over 5 years. And as such, we've invested a lot of time and capital to understand the subsurface, maximize the oil recovery on these lands, and also the infrastructure development that we've invested in to minimize the surface impact, minimize the truck traffic by building out our pipelines. We are ready for these wells, and by allowing another operator to come into these lands that doesn't have the same existing sites, the same facilities that are ready to go, the same pipelines that are ready, this doesn't reflect any industrial logic, and it certainly doesn't seem beneficial to Colorado's environment or public health. I have been following some of the activity over 2018, and there have been plans presented, comprehensive plans of development that have similar benefits that we're speaking to today on our proposed plan. And these plans have been accepted and regarded very favorably. And we ask that in the same spirit, in the previous proposed plans have been regarded favorably and accepted. We are asking that our plan that we're proposing be approved today. And we thank you for your time in listening to us.
You talked about a centralized facility, and you've got exhibit 4 up. That depicts where that centralized facility is that right?
Yes, as Max said, we call it the super section. It's the orange square in section 26. This is within a half mile of the proposed development in sections 24 and 25. And we are currently bringing some wells online in section 28, which is to the west. This was the section that was discussed when we talked about traversing existing diagonal wells. Section 28, we believe at Bonanza in full development now. Everybody, to go back and do things differently in the past, we all wish we could do that. But our go forward is full development of an area. And so currently we are bringing 14 wells online in Section 28. Those 14 wells are all being taken to the super section in Section 26, which is 2 miles away. And this is, so the super section, we've built the super section to be modular, and we will have 68 wells currently going to the super section centralized facility with our current Section 28 that's coming online.
You were seated just behind Ms. Burnett when one of the commissioners, I think it was Mr. Boygan, Commissioner Boygan, talked about concerns regarding what the drilling might look like as you transect these wells, which are drilled on either diagonal or completely east-west instead of north-south. Do you have any information for him that you can provide?
In terms of avoiding the existing wellbores, we have a lot of options. We can go over the well, we can go under the well, and we would look at the seismic panels, and we would look at the regional stress maps, and we would work with our execution team to plan the best way to avoid those wellbores. And as Christina mentioned, we've done it in other areas of our own acreage, where based on the vintage of those wells, that was the practice in the DJ to do diagonal wells. They were good for several reasons. At the time, the understanding of the stress, the regional stress, it was optimal to drill the wells diagonally. It was also good from in terms of holding a lease. If you had a diagonal well, you held more leases with the diagonal well. Obviously, as companies move to full-scale development, diagonal wells don't make for good maps. It's very hard to fully develop sections on a diagonal basis. So regionally, we all switch to either north-south or east-west. And so this is not a new problem where you have an old diagonal well that you have to avoid as you infill. And as Christina mentioned, we just drilled 10 actually XRLs, 2-mile laterals, avoided an existing well, and then we fracked our new 10 wells, and the existing well has actually returned to production to equivalent forecast. And it's something we actually are watching very closely and spent a lot of time as engineers looking at the parent-child relationship and working on how to improve the parent recovery.
There's also been some concern regarding the west half of 24. Ms. Burnett talked about that and why those vintage wells, those older wells, which are operated by Bonanza Creek, don't call for any continuing permits right now. Do you have anything else that you might want to provide the commissioners in supplement to what she might have said?
No, I don't have anything additional to add beyond what Christina already said in answer to that question.
I have no further questions for Ms. Lima.
Ms. Jost.
Thank you. Ms. Lima, just 2 quick questions. Despite your statement of being the current and sole operator on the application lands, isn't it true that Noble does operate 3 producing wells on the application lands?
And yes, they do. And as I said, we are the sole operator in the acreage surrounding the application lands. I think the Act describes operator, producer, and owner. And we have been the active operator and producer of the acreage surrounding the application lands for over 5 years. And the reason I say that is because we have been submitting active permits. We've been active in the drilling. We have a valid surface use agreement with the ranch. And that's just not the case for everyone.
Okay, thank you. And then just to confirm, the traversing tests that you described on other areas were on Bonanza's own acreage and wells, correct?
Yes.
Okay,
Yeah, we can
thank
only
you.
do engineering in our own wells. And so we've been obviously, I'm not going to say that we're the only company that's working on the parent-child relationship. It's a known issue in the oil and gas industry, and many engineers and many basins are working working on that issue, helping the parents recover. And we have done We've invested time and capital in our own wells as we traverse old wells with new development.
Great, thank you. No further questions.
I have one follow-up if I could, just to redirect
Absolutely,
her
Mr.
again.
Willis.
You know, when Ms. Jost was talking to you about your response to the question, to one of her questions was dealt with you being the operator in the region surrounding these application lands. As they exist right now, these lands, are they somewhat of a hole in your plan?
Yes, they are.
Right, and this would fit that that missing piece of a puzzle, is that right?
Yes.
All right, thank you. Nothing further, thank you.
Commissioners, any questions? Briefly, one. The 3 Noble wells that are operated, where do they produce to a single battery? Are there 3 separate batteries? And is that, I'm assuming that oil gets trucked out of there.
I can only say that I've noticed a pumping unit, but in terms of answering that question, it's probably more suited for a Noble engineer.
We'll ask the Noble engineer when that opportunity comes. I was just curious if you knew that. So,
I've looked over the fence and saw a pumping unit.
all right, thank you.
If there are no further questions, I don't have any additional witnesses.
Commissioner Boygan.
Mr. Chair, thank you. So what I'm hearing you say is that you're not sure yet what you're going to do, but to cross these wells, but you're going to do something that's in accordance with conventional engineering practice that's been done in many places elsewhere throughout the basin. Is that correct?
Yes, and with our own experience in the last, so in our last, I would say 6 months of drilling, we've traversed 2 diagonal horizontals with full scale development of the section. And so we have our subsurface team, and then we have an execution arm. And I would lean on the expertise of our execution engineers in terms of how they want to avoid those wellbores.
Could I ask, are those your own wellbores, the ones that you've crossed, or are they other parties' wellbores?
They are, in this case, the ones I'm speaking to are our own. But one of the surveys that is posted to the Oil and Gas Commission is the directional survey of every horizontal. It's a requirement. That's something we have to share with the state. And so as an operator, we can look up the directional survey of another operator's horizontal and use that in our own planning of our own new wellbores.
What I'm getting at is if it turns out that in your crossing of these wells and you're fracking into these wells, you cause the wells damage, is it your plan to compensate Noble for that damage?
So I think one of the unique and very special things about the DJ Basin is the way that we've handled the horizontal infill program. So on a weekly basis, companies within the DJ share frac schedules with each other openly. And we have a call every week, and we have regular meetings. And the spirit of that is to work together. We are all threading the needle, as it said, where we're coming back in and reoccupying lands. The technology's improved, our understanding is improved. And so reoccupation of areas is very common in the DJ. And there's a history and a precedence here of working with other operators, not only after the fact, but ahead of time. So we have to give 90 days notice of operators that we are going to do a stimulation. And we have to make sure that those wellbores are prepped according to an SOP and a standard, that those are ready to avoid contamination of the aquifer, to avoid a surface release. And so we would be more than willing to work with Noble ahead of our simulation and also after the simulation if something happens. That is a precedent, and there's no written rule of what that is, but we would certainly be open to that conversation with Noble, depending on if it's a pre-simulation mitigation or a post-discussion on stimulation after the fact.
Okay. I'll take that as a qualified yes, you're open to a discussion on compensation. I don't have any further questions for now.
Okay, just to clarify, no specific concerns about, from an execution standpoint, about being able to keep those new horizontals 150 feet or more away from the existing ones.
No,
Good enough. Thank you.
thank you.
Can I just get a time check, Ms. Larson?
Yes, you have 21 minutes and 20 seconds.
Thank you.
Very good. Commissioners, would you like to have a break before we start with the Nobles case in point? Or case in chief?
Turn down a break.
Very well. We'll try to start again at 4 o'clock. Are you ready?
I am, thank you.
Okay, proceed.
Our first witness will be Mr. Brian Bolton. He's going to testify as to the land aspects of Noble's position on this hearing. We've already qualified or stipulated qualifications. So Brian, could you just provide your full name, title, and quick responsibility list at Noble?
Yes, thanks, Jimmy. My name is Brian Bolton. I'm a staff landman at Noble Energy with 10 years experience. I'm familiar with the lands and the development plan put forward by Bonanza Creek. I'm responsible for all prospect development in this geographic area of the DJ Basin for Noble and commission related matters.
Great, thank you, Brian. And we're going to start with Exhibit A. So Brian, can you please describe Exhibit A and Noble's leasehold interest within the 1,280 acre unit proposed by Bonanza Creek?
Sure. This exhibit just shows 100% Noble leasehold in section 25, 75% leasehold in the the east half of section 24, and Bonanza's is 100% leasehold in the west half of section 24, as well as showing the fee acreage in the east half of section 24, or the federal acreage, and the remaining portion of the DSU is fee.
Okay, so just to confirm, the entire east half of section 24 is federal minerals, correct?
Correct.
Okay, so Brian, are the mineral interests common in the west half of section 24 and the entirety of section 25?
No, they are not.
Okay, so those different mineral interest owners would have benefited from their respective 320 acre unit development and the 640 acre lease development, correct?
Correct.
Okay. And if the 1280 is approved today, Noble's leasehold and mineral interest owner in section 25 will be affected by the already drained acreage in the west half of 24, correct?
Correct.
Okay. And as of your knowledge, as of today's hearing, Bonanza has not submitted any federal APDs to the BLM for the development of the east half of 24 or 25, correct?
That's correct. Noble is not aware at this point in time of any federal permits filed on the east half of section 24, as well as there's not been a 2A filed on the east half of 24 as well.
Okay, so would Noble utilize this as that there is no evidence of Bonanza's intent to develop the eastern half of the 1280 unit?
Not of this time, there's not.
Great, thank you. So flipping to Exhibit B, Brian, before we dive in, go ahead and flip here. Can you please tell the commission why this exhibit is important for the commissioners to understand as part of Noble's presentation?
In order to fully evaluate this DSU proposal, we needed to look at the applications for permits to drill to see what the actual development plan was. So on this exhibit, you can see the hashed red would be representative of what Bonanza intends to develop, kind of overlaying our 100% leasehold in section 25, as well as 75% leasehold in the west or the east half of 24.
Okay, and Brian, isn't it true that this exhibit outlines 14 APDs while the actual unit is requesting up to 20?
That's correct.
Okay, so if additional APDs were filed in here, that would just increase the harm to Noble's interest, correct?
Correct.
So as a leasehold owner of the 100% in section 25, Noble has leasehold obligations to its mineral interest owner, correct?
Correct.
And Noble has an obligation to review not only Bonanza's proposed size of the unit, but also the proposed development plan for the unit, correct?
That's correct.
Okay, great. So you already kind of walked the commissioners through Exhibit B, but if you could maybe give a little bit more explanation on the west half of the of section 25, the well bores there. Do you know how much footage Bonanza Creek would actually have in the west half of section 25 wells?
Looking at the APDs, the top of the producing zone for those west half wells, it's 500 feet from the south line in section 24. So they would be producing roughly 500 feet of lateral length within their own leasehold. The remaining portion of that lateral on the west half wells is all 100% Noble leasehold.
So basically a super majority of the west half of section 25 wells would be Noble's 100% leasehold, correct?
Correct.
Okay. And just a reminder to the commission, you heard testimony earlier today from Bonanza's witnesses that the 6 wells in the west half of section 24 are producing, correct?
Correct.
And has Noble shared in those wells?
No, Noble is not shared in the production on the west half of section 24. That's 100% Bonanza leasehold.
Okay, excellent. So, and one additional question, if this unit is ultimately approved, will Noble object to and seek a hearing on Bonanza's APDs?
Yes.
And why is that?
Noble cannot be on board with the development of its 75% leasehold in this unit. And so we will have to take every step necessary to protect our leasehold.
Okay, and that's to protect existing producing leasehold, correct?
Correct.
Okay, so this is not an instance where we do not have kind of undeveloped acreage that could otherwise be incorporated into a unit and paid out on a unit basis, correct?
That's correct. I understand that this commission looks at a lot of these drilling and spacing units for unproductive lands, and that is part of that, but that's not what Noble sees here. There's production on Noble's leasehold, 100% leasehold in section 25.
Okay. And Brian, you heard Bonanza Creek's testimony that we're only here because we're a majority interest owner, correct?
Correct.
And is that the case?
No, I don't believe so. I think Mr. Faith testified that he reached out to Noble in April of 2018. However, the original application was filed in January of 2018. Noble was not approached before the application was filed. It was just kind of showed up on our doorstep, and then we were left to deal with it as a play for leverage and trying to use this commission as a way to force Noble into negotiations.
Okay, great, thank you. And you also heard testimony from Noble's, from Bonanza Creek's witnesses that they are going to, take care of your well bores later down the road and, stay off of the well bores 150 feet. At this point, have you received any offset waivers or requests for waiver from Bonanza for these wells?
No, we have not received any 150-foot waivers for the existing horizontal wells in section 25.
Okay, and do you have a concern with this 150-foot offset testimony?
I think obviously if they plan to stay 150 feet off of each of our existing horizontal well bores, that's 300 feet for each well bore. So totaling up for the 3 well bores, roughly 900 feet of unproductive lateral length within Noble's 100% leasehold.
Okay, so with respect to Exhibit C, we'll go ahead and move on. Brian, we don't really need to probably remind the commission at this point of your 100% interest in 25 and 75% in 24, but can you please describe Noble's producing wells in the unit as proposed? So the 3 blue wells, that's okay.
These wells were drilled in 2010 and 2012. Kind of some of them were our initial first run at horizontal development in the DJ Basin.
Okay. And these wells are still producing though, correct?
That's correct. And Mr. Marini, the engineer, will testify later to the actual production and how much they are producing.
Okay, and your mineral interest owners have been receiving royalties and revenues from these wells since production began, correct?
That's correct.
Okay, and Bonanza has never shared in these wells, correct?
That's correct. They don't have an interest in the lease.
Okay, and so Bonanza has clearly known about Noble's production for years prior to bringing this unit to the commission, correct?
Correct. The wells that in the west half of section 24, but that Bonanza drilled were 2013, 2014 vintage. So Noble's existing horizontal production just to the south were there for somewhere between 3 and 4 years before Bonanza Creek began operations.
Okay, great. Thank you. And Brian, you've reviewed Bonanza's Exhibit 18, correct? And I'm referencing this exhibit just so I don't have to spend time going back to the other PowerPoint.
Correct.
Okay. And if development was to occur in the east half of Section 24, it could be done on 1 mile laterals, correct?
That is correct.
Okay. And this can be illustrated by Bonanza's own production in the surrounding acreage where it purports to hold a leasehold, correct?
Correct. I mean, if you look at the existing production from outside in this area that Bonanza's developed, they have no problem developing leases or their wells on 1 mile lateral length.
And you can see on the adjacent sections, and I'm going to direct you to sections 18 and 19, 17, and 20. So I'm looking at this, basically these 4 sections on Exhibit 18. You can see that there are planned 2 mile horizontals in there, correct?
Correct.
Okay, and now those planned 2 mile horizontals still stay on Bonanza's own acreage, correct?
That is correct.
And those would traverse Bonanza's own wells, correct?
That's correct.
Okay, thank you. Okay, so we're going to flip to Exhibit D. And this is just for the commissioner's basis. Can you please just walk us through this exhibit outlining the orders that are actually in place and the correct nature of those orders?
So there is one order in the west half of section 24. It's a spacing order filed by Bonanza for development of one horizontal well. There are no orders in the east half and no orders in section 25.
And order 407707, the one addressing the west half of section 24, that is actually classified as a horizontal wellbore spacing unit for a 320 acre unit, correct?
That's correct.
Okay, thank you. And with respect to exhibit F, E, F, and G, just for the commissioner's summary, this is a summary of our full exhibits, but we have just placed it in a very short summary slide here. Can you please describe the significance of this exhibit to the commission?
This is an overview of the three existing horizontal wells producing in section 25, where it gives evidence that Noble has held the acreage. We are paying revenue on the production to our to our royalty owners, and we've held value in our leases by development of this acreage.
And just to confirm, these are all Niobrara producers, correct?
That's correct.
Okay. So if the Bonanza Creek unit is approved and the wells are developed, that could lead to inefficient development of your producing wells, correct?
That is correct.
Okay. And Brian, to your knowledge, are these wells economic for Noble?
Yes, they are.
Okay. And can you please expand on that from the land perspective?
We've developed this on a lease basis, so we have been able to hold our lease with these three existing horizontal productions and receive value for the investment that Noble initially had in acquiring its own lease.
Excellent. Thank you. And with respect to exhibits H through U, the summary that's provided on the screen, can you please describe the significance of this slide to the commission?
These are the 14 applications for permits to drill that Noble has received from Bonanza, filed by Bonanza. The majority, all 13 of the 14, are targeting the Niobrara Formation, which is where Noble's existing three horizontal wells in section 25 are already producing in the Niobrara.
Okay, and can you confirm that none of these 14 wells actually will produce from, will go up into the west half of section 24 where Bonanza's existing wells are? Back here.
They're all, yes, that's correct. They all run south. There is some overlap there on the south half of section 24, 500 feet roughly of productive interval.
Okay, and then just to confirm though, all 14 will be purportedly developing Noble's 75% interest in the unit.
That is correct.
Okay. I'm going to flip ahead to Noble Exhibit BB. Brian, you heard Bonanza's witness claim that Noble has really no infrastructure in the area, no development plan, and it's just basically going out there and sounding like they're going to just bust up the surface. Can you please describe this exhibit to the commission and explain why that is not a true statement from Bonanza?
Yes, this exhibit shows Noble's infrastructure in the area. It's an NBLX infrastructure, so this is Noble-owned infrastructure that Noble's put in and used to develop the already existing production in Section 25.
Okay. And with respect to the pipeline that you see from Section 25, is that your takeaway capacity for the three producing wells?
Yes.
Okay. And just to point out the fact that there have been statements made that there's a, quote, Noble competing development plan, what do you say to that?
I believe that this shows that we don't need a competing development plan because we already have a development plan in Section 25 producing and developing our acreage.
So is this a typical operatorship fight where you see development plan versus development plan?
We don't see it as a typical operator fight. This is Noble protecting its 100% leasehold where it already has existing production and it's invested in this area. It is not a simplistic operator fight in the way that we don't want to be here anymore doing this than you want to be here listening to this. But at some point we have to put our foot down and protect what we've already developed, what we've spent Noble's money to acquire these leases. And we see this as a land grab by Bonanza Creek.
And just to wrap up with that, should Noble be forced to put a competing development plan out there just because that's what we've seen in other operatorship fights?
We don't believe that filing an APD is evidence of a development plan. Anyone can file permits. I think everyone at this commission is aware of that anyone can file permits. What should be evidence is Noble having already drilled the wells and is already producing in this section.
Okay, thank you. And Brian, maybe one more question for you. And I think you may have already addressed this, but you did hear Mr. Faith testify about Bonanza Creek's outreach to Noble, correct?
That is correct.
Okay. And in that outreach, was there anything proposed that Noble could actually accept that would take away from its 100% existing produced lands?
No, I mean, Noble will always listen to another operator's proposals. However, everything put forward by Bonanza Creek was not acceptable to Noble.
Thank you. No further questions.
Mr. Willis.
Thank you, Chair. I just have a couple of questions for you, Mr. Bolton. First off, Mr. Bolton, it's possible, is it not, that Bonanza Creek could have submitted federal permits and you haven't picked up on them yet? Is that right?
They're not showing up. We don't see them. I have no notice of them.
And you're aware that there's a work stop, or at least there was problems with the federal government for the last 6 weeks or whatever, right? So they could be in queue right now.
That is correct. I mean, we did receive the initial application back in January of 18. So, I mean,
Okay.
and we hadn't seen anything to this point, so.
That's fair. What I'd like to do is, talking about the west half again of 24, there's one well that Bonanza operates there that's producing under an existing spacing order for the west half. And then the other well bores, whether they be Cornell or Niobrara horizontal wells, are producing under well-bore spacing units. Is that right?
That is correct.
All right. So you're not getting any of the production from those, right? Because you don't have any ownership within either the west half, which would entitle you to production. Is that right?
That's correct.
All right. And similarly, with regards to the production that's being pulled from 25, Bonanza Creek doesn't share in any of those proceeds. Is that right?
That's correct.
All right. And why is that?
Because Bonanza Creek doesn't have an interest in the leasehold.
Okay. So it's kind of the same, right? So, you talked about 1 milers and 2 milers. Is there an economic advantage to producing 1 mile or 2 milers over 1 milers?
I'm not an engineer. I can't answer that question.
There could be though. And then just one more question. Just a moment. Is there anything else? You talked about the waste and the 900-foot area of waste. Could you describe that again as to what you're talking about or what you're trying to describe?
Noble hasn't received any 150-foot waivers. So 317S waivers. So Bonanza Creek would not be able to complete within 150 feet of Noble's existing horizontal production on either side of that wellbore. So if you're traversing 3 Noble horizontal wells and you can't produce within 150 feet on either side of that, just multiplying that by 2 and then by 3, that is 900 feet of production.
Okay. But the wells that Bonanza Creek is planned now are not existing. Is that right? They haven't been drilled.
They haven't been drilled. It's
Right.
just sort of speaking to the
So if in
development.
fact those well bores were drilled, it wouldn't surprise you if you did see the waivers at that time.
I'm going to object as to speculation.
Thank you.
Thank
Nothing
you.
further.
We'll sustain that.
Thank you. I have no further questions.
Short redirect.
Very well. Commissioner Boygan.
Thank you, Mr. Chair. I'm not sure if I've heard this correctly. Are you saying that the Noble leasehold in section 25 is fully developed?
I'm saying it's been developed by 3 horizontal wells that are producing, and Noble is receiving roughly $67,000 a month in gross revenue.
Right. But are you saying that no additional economic wells could be drilled in section 25?
No, I'm not saying that.
Are your leases in section 25 fee leases?
It's one lease. It's
One
held by
lease.
production.
Have you considered, you said that you had obligations to your mineral owners. Have you considered potential exposure to a claim for breach of implied covenant of further development if you don't drill additional wells on your leasehold?
No.
Okay, no further questions.
Just a moment, please. Okay. Yep. Sorry, Ms. Joseph, I think you have a redirect and then we'll go back to questions.
Okay,
So,
thank you. Just a quick redirect. Brian, you heard Mr. Willis's questions of Bonanza participating or not being able to recoup the revenues from 75 because they don't have an interest, and Noble not being able to recoup revenues from the west half of 24, correct?
Yes.
Okay, and doesn't that lead you to the conclusion that you should just each develop your own leasehold?
We believe that every prudent operator in the basin should be developing within their own leasehold. And this is an instance where there's been an overstep by Bonanza, and they are seeking to use this commission to produce our leasehold and use this commission's rules to accomplish that goal.
And as a 100% interest owner in Section 25, shouldn't Noble be the one to determine the next steps for development of that interest?
Yes, and I believe this goes to Mr. Boygan's point that if Noble is going to further develop the lands in Section 25, we should do it on our own time when those wells have been depleted and we can do it efficiently. That's not the case now. There's production there. We're producing those wells, and there's not a need for us to do that now. And that's not what this is. This is us saying we already have production here, and we're going to go with that because it is on 100% Noble lease.
Okay. And Mr. Marini may testify to this as well, but is it Noble's intent to continually develop the Section 25 in the future?
Yes.
Okay, thank you. No further questions. Thank you for the allowance.
Oh, no problem. I'm sorry, I forgot about that. So, wait.
You may have some. I don't have any further questions, but they may.
Some of the commissioners may have questions besides myself. Commissioner Hawkins.
I was trying to explore this a little bit earlier. What's concerning me, and I guess probably concerning you, is that the 1,280 acre spacing unit proposed is including all of the west half of Section 24 to contribute to equity, but it's not really going to contribute any more production that I can see. It could, there could be another well or two or something drilled up there, but I guess what I'm trying to get at is, how do you view that that equity determination by including the west half of 24?
Mr. Hawkins, we were right in line with your thought there that including that west half of Section 24 acreage that's already been developed by Bonanza Creek, including it in the 1280 spacing unit, was just a way for Bonanza to increase their working interest in the unit as a whole. And that's the only purpose that it served in this instance.
And I guess in Section 25, since you have two surface locations apparently there right now, could you develop additional wells from those surface locations?
At some point in the future, yes.
Yeah, you wouldn't have to use the surface locations that Bonanza Creek is proposing.
No.
No more questions.
Okay. We've already established that you don't share in the Section 24 wells and they don't share in your wells. So we already established that. I'm curious about, and this may be a question for staff on this 150-foot setback offset. Is that two-dimensional or three-dimensional? Meaning that if they essentially drive their wells more than 150 feet over the top of these existing wells, does that constitute the 150-foot offset?
We can get the answer for you. I don't have that answer, but I can ask Mr. Ellsworth or Ms. Stanzik, who would be able to answer that, to have
I
them
would
come.
like to have
Okay,
that answer,
we'll get
please. Yeah, because it ties to the 900-foot. Yes, Mr. Wells.
If I could, Commissioner, we'd be looking in a 3D world here. We understand that there's 3D development here, and the 150-foot setback basically is somewhat of a legacy with regards to a safety setback, which used to be part of the Oil and Gas Commission rules, that there be a 150-foot setback. And that's 150-foot. What we're looking for under the development order is an order requiring any permitted well to be 150 feet back from any productive interval of any existing Codell and Niobrara well. So it would be on a 3D basis.
I would guess that Mr. Ellsworth has extrasensory perception since he just walked into the room.
And Chairman Benton, if I may, after Mr. Ellsworth address this as well, because I'm not sure Mr. Willis's statement on the actual Rule 317 RNS was spot on. Thank you.
Okay. So the question came up, Mr. Ellsworth, is, and you're right, Mr. Willis, I was trying to think of this in 3 dimensions, although it's, sometimes difficult for old engineers to think that way because we're used to flat pieces of paper. What is the requirement when you permit wells and it's essentially 150-foot offset when we're looking at this case where there's going to be potentially horizontal wells going over top of existing wells. Is that 150 feet this way, this way? Do you draw a 150-foot radius around the existing well? How does that work?
We do think of the 3 dimensions. And what we're looking at is kind of 2 parts to that, and that's our 317 R&S rules. We're looking at an anti-collision perspective. And so that's where we want to know where the well bores are so that one doesn't physically damage the other. And then we look for the 150 feet also to be if you're inside of that, we want to notice to the other operator that you have reached out to them and acknowledge that you're close so that we can at least be aware that other operators are aware you're coming very close and have a perspective of the frac hit question.
So that goes to a previous comment, I think was made that there was a question about whether or not Bonanza Creek could contact Noble about the drilling program. If they intend to stay at least 150 feet away from those well bores in a 3D sense, then they wouldn't necessarily be required to notice Noble about that.
Well, it is something we look for in the drilling permit. So if you're closer than 150 feet, we look for a waiver. So that that waiver is that somebody has acknowledged and said, okay, I'm okay with that.
So if it's more than 150 feet, then the waiver's not required.
That's correct.
Okay. All right. Is that anything you wanted to add to that, Ms. Jost?
No, that was exactly what I would like to address was the 317S, kind of the don't frack my well rule.
Yeah.
So thank you.
So notionally, if they are 150 feet away this way, it really doesn't freeze out 900 feet from the existing wells. So I think I want to make sure that that's clear.
Yeah.
Because you don't have to do that. I mean, if you're 150 feet away, it doesn't freeze out 900 feet. I'm assuming that you have a surface use agreement in place with the 70 Ranch folks.
I'm not aware. I mean, we've developed this, so we have a surface use agreement within section 25. So yes.
Okay. And do you know if that surface use agreement allows for any additional development on these existing pads or any other pads?
I don't know what the surface use agreement looks like.
Okay. I think the rest of the questions I had were related to your engineer. So thank you.
Thank you. Great. Thanks, Brian. Oops. I went one too far. Thank you. Let me back up real quick.
I actually did have a land question. I apologize.
Yes.
Or I may. Would Mr. Bolton have familiarity with your Exhibit Y?
Exhibit Y. Let's flip to that just real quick and I can ask him. Brian, it's this one. Oops, sorry, the land acreage.
Yes. Very well. What's the basis for the value of 15,000 an acre? We just recently heard testimony that somewhere where leases value were significantly less than that. So I'm just sort of curious, is that to do some kind of a search out here and that's the current market value of this, or how did you come up with that number?
Yes. So Chairman Benton, Mike Marini is actually prepared to address Exhibit Y with respect to the market value of the 15,000 an acre as well.
Very well.
If we could reserve that question.
Certainly.
Thank you. Okay, so Mr. Marini, again, qualifications have been stipulated to. So if you could just please provide your full name, your title, and your responsibilities at Noble, that would be great.
Sure thing. Mike Marini, petroleum engineer, worked in the oil field for about 11 years, and I'm familiar with these lands and with the existing wells that are producing within.
Okay, great. And we're going to start with Noble's Exhibit V. And can you please just describe this exhibit to the commission?
Sure. This is a refresher slide to introduce my portion of the evidence today. As you can see here, Noble does, as we discussed, own and operate these 3 wells they are producing today. Bonanza Creek owns and operates these 4 wells today. That is their leasehold. They own 100% of those wells as far as we know. We own 100% of these wells. We believe that Bonanza Creek owns and operates about 60 acres of the east half of Section 24. Noble Energy has leases over the rest of it, and that's all that remains. It's undrilled in this section. The fact that Bonanza Creek is, has a unit here that's 1280, but not infilling these existing short laterals that they have, it's an abuse of the commission rules to do this. And we really need to stand up for the mineral owners in Section 25, because they're going to have an unfair burden, because their mineral checks are going to get cut short because they're having to share with the folks over in the west half of 24. And that's not the case, because the west half of 24 is not getting any new development. Those are the folks we need to stick up for here today. And Jim.
Okay. And with respect to the 14 wells that are shown, you've also heard that Bonanza is actually seeking up to 20 wells within this unit, correct?
Correct.
And does that just propound the impacts of harm to Noble's development and Noble's existing acreage?
Yeah, if there were additional wells listed, that would be too many straws in the Coke glass, as you could put it, and it would have an economic harm to this project. And as we're the majority owner, we wouldn't want to consent to a project like that.
Okay, excellent. Let's go ahead and flip to Exhibit W. And actually, you know what, Mike? I think we could probably, nope, I'm sorry. Let's go ahead and describe Exhibit W to the commission.
Initially, this exhibit was submitted to illustrate Bonanza Creek's 460-foot boundary setback and how the Codell well on the west side, illustrated by the red star, violates that setback at 318 feet. That said, it turns out that the Codell well was submitted as a Rule 318A WSU well that neither Brian nor I were aware of. While Noble objects to this Codell well, the objection will have to be dealt with through other commission processes down the road at a later date.
Okay. And Brian, whether that Codell well is a WSU well or a drilling and spacing unit well, does it change the fact that it affects your 100% interest in Section 25?
Yes, it does. It traverses 100% of Noble Energy leasehold.
Okay. And would that well ultimately interfere with Noble's potential future development of your 100% interest in the leasehold?
Absolutely, it will.
Okay, thank you. So please turn to Exhibit X. So Mike, I think I may have called you Brian, I'm sorry.
That's
Mike.
Okay. I got it, sorry.
Can you please describe Exhibit X and your analysis of the damages to Noble if you're forced to participate in this unit and the unit is actually approved?
As I mentioned before, 320 acres of the unit is drilled. What remains is about 60 acres of Bonanza Creek acreage, about 264 acres of Noble Energy acreage, and then down here in Section 25, a full 640 of remaining acreage is 100% Noble. So what that equates to is a 70+% working interest for Noble Energy. Now, if you take Bonanza Creek's most latest AFEs, which they shared, if you take their AFEs, multiply them by the working interest, multiply the well cost by the well count, you come up with $40 million of cost to Noble Energy. This is no small bill because of the ownership issue here. We do not want to fund a Bonanza Creek project at Noble Energy. We don't want to fund other operators. We just want to fund our own projects, folks. And the net cost of Bonanza Creek are only $17 million. This is unfair. What we really need to ask here is bullet point number 2. Why is this not a smaller DSU? I think the real reason is that if it was a smaller DSU, if it was reasonably set up as a 960, Bonanza Creek's working interest would be too small and too low to reasonably drill these wells.
Thank you. Let's go ahead and continue on to Exhibit Y. So Chairman Benton, we will address the questions that you are asking of Mr. Bolton, and Mike will address the lease acreage as well. So if you can please just walk us through Exhibit Y and why this exhibit is important in this context to the commission to understand.
Absolutely. If the unit were approved and these wells were drilled by Bonanza Creek, Noble Energy is not going to be able to pay $40 million to support this other oil company's program. Therefore, we are out of the well for 2 times payout. That's in the lease language. And, what that basically means is the future value of this lease, because it's drilled out and because we're kicked out of it, to Noble Energy, it's effectively zero. Today, we would value this acreage at $15,000 an acre, multiply that by 904 acres. That comes out to about $1.4 million in losses to Noble Energy. How we came up with that $15,000 an acre? This is trophy, low GOR, core DJ rock. The $15 an acre is based on an economic analysis of what Noble would do in this area for well results. It's also very in line with market value. We've seen rates higher than this in higher GOR and worse parts of the DJ, actually exceeding $15,000 an acre. This was a bit of a bargain for this region today. The DJ is not necessarily consistent in well performance across all the townships. This happens to be a very special and very important area and an area of Noble's focus.
Thank you. And Mike, just for clarification, were you privy to the acreage values that Chairman Vinton was referring to in an earlier hearing today?
Yes, I was.
Okay. And those were on much different lands, assuming much different lands and assuming much different geologic acreage, correct?
Correct. And
Okay.
actually, I think it was higher GOR acreage. This is much oilier.
Okay, great. Thank you.
GOR 4.
Okay. So then for purposes of continuing on, if you can please flip to Exhibit Z. And so Mike, can you please describe Exhibit D to the commission and the damages that will happen to Noble's 3 producing wells if Bonanza Creek's unit is approved?
Absolutely. So we do have currently producing 3 existing wells. They're the 70 Ranch BB25 wells. In the month of December, these wells cumulatively produced 1,100 barrels of oil and 3,600 MCF. This is pretty steady production for us today. That yields a gross revenue to Noble of about $66,000 a month. If the 14 wells from Bonanza Creek were to be approved in this unit, the frac into effects are going to be substantial. Mrs. Burnett had mentioned in her testimony that they were going to use enhanced completions at Bonanza Creek. What that means is they're going to use smaller stage spacing. They're going to pump more sand. They're going to pump more gel and more water. And we call this a frac hit. They call it a frac hit. It's called a frac hit for a reason. It's not a frac uplift here, folks. It's a rare event, very rare event in the DJ today that when you frac into a well that you see an uplift in production. That is like a unicorn oddity in the DJ. With how this is set up, where 14 wells are going to traverse this project, these wells are going to be destroyed. There is no way to salvage this. There's no technology today to salvage this. And this is the effect. This is the same as on a workover rig if you're pumping kill fluid down a well. And unfortunately, this is a loss to Noble, and we really can't stand by and let this happen. Also, subsequently, bullet point number 2 down here, it does say Noble will be required to P&A the wells. So not only are we going to lose $66,000 a month in revenue, we're also going to have to pay the plugging bill on this. There's been no efforts from Bonanza historically to try and pay for our plugging bills. Nothing I'm aware of. This is a loss for Noble.
And Mike, just a couple of follow-up questions. So when you say that Noble will pay the P&A cost of this, will Bonanza Creek share in any of the P&A costs because it's Noble's 100% leasehold?
As it is 100% Noble and they have no ownership in those wells, they won't pay $1.
Okay. And from your perspective, should another operator be allowed to traverse your wells knowing the frac hits will damage your wells?
No, I don't believe that is reasonable. I don't believe it's reasonable to expect these folks, to expect Noble Energy to have to take the risk on that frac into, right?
And would you consider that inefficient development from Noble's standpoint?
Yes, because if Noble were to come in here and develop this acreage at a later date, which we have plans to do so, we'd like to go ahead and time the new production with the decline of these existing wells, and they're currently producing substantial revenues for us.
And with respect to the admission by Bonanza Creek about that they will frac into these wells and your statement that the frac hits will occur, does the 150-foot waiver actually have a purpose here, or is it just kind of a red herring?
Good question. Red herring, because the DJ is well known to be a naturally fractured reservoir and because they're using enhanced completions, there's no hope to save these wells.
Okay. So even if they're 150 off in a 3-dimensional capacity, your wells will still be damaged?
They will absolutely be damaged, even at 150 feet. Fracs do travel more than 150 feet here in the DJ. We see that on microseismic. It's well known. There's no hope for these wells.
Okay, thank you. So Mike, I'm actually going to have you turn to Bonanza's Exhibit 16. And again, without going out of the PowerPoint, in the essence of time, it is the small exhibit that looks like this to the commission. So Mike, can you please describe your concerns with this exhibit and tell the commission why you felt it was important to reference this exhibit?
I do. This is actually my favorite exhibit in the whole presentation today. So what this shows is, and this is from Bonanza Creek, this is a requirement to submit a drilling and spacing unit in Colorado, is you have to supply a drainage area per well. Now, what they've calculated is that one Niobrara well will drain 37 acres. Now, they only own 60 acres of undrilled Niobrara today. So by that logic, they've got enough leasehold for 2 Niobrara wells. The Codell here indicated on the tables drains 115 acres per well. They don't have enough acreage for even one Codell well. They also have enough ownership for a very small vertical well project, but they don't have enough to drill 14 wells, right? They don't have the ownership for that. They're going to have to reverse Noble's leasehold. They're abusing the commission rules to do this. You know, by this logic, we want you to deny this application today.
Okay, thank you. And back to your exhibits with respect to Exhibit AA, can you please describe this exhibit and your analysis of Noble and Bonanza Creek's well performance to the commission? And please tell them why this is important.
Absolutely, Jamie. So what this map is here on the left-hand side is the green wells are all the latest Noble Energy wells in the area adjacent to this project. The blue wells are all the Bonanza Creek wells adjacent to this project. And I've only pulled 2017 and newer wells, all the old stuff we left off. Now, if you normalize all the well results, all the EURs from these wells, if you normalize them all to 9,500 feet, or in other words, a 2-mile lateral, you can see that Noble Energy pulls off an average EUR of 960, or call it 1,000. You know, you can see that Bonanza Creek pulls off a 670 EUR. You know, Noble Energy consistently sees well performance that beats Bonanza Creek by as much as 40%. So if you're in my shoes and you're here dealing with non-op projects and getting new wells approved in the basin, and you got to go to your management team and ask, hey, you know, folks at Noble, can I get $40 million to fund a Bonanza Creek project? And then you show them that, geez, their well results are 40% worse than ours. You kind of get laughed out of the room. So we really can't fund this project at Noble. We don't want to participate in it. We don't understand why it's not being done as a 960. And this has serious economic impacts to Noble, because not only are they asking us to, hey, Noble Energy, we're going to go ahead and destroy 3-year wells and $66,000 a month of steady revenue. Hey, by the way, Noble, you're going to have to go ahead and P&A these wells. You know, hey, Noble, if you don't pay us, then the leasing value of $1.4 million goes to zero. But you also, at the end of the day, if you do participate, you get 40% worse well results. This is a deal, and we really need the commission's support here to deny this application.
And Mike, just one final question on that. With respect to the 40% difference of production with everything that you've heard today, is it fair to state that Noble would be funding 70 to 75% of the destruction of its own wells?
Yes. And these well results are in line with a company that declared bankruptcy 2 years ago. It's not a surprise.
Okay. So Mike, one last question. Is there anything else you'd like to tell the commission today about Noble's development of its own acreage?
Yes. When the time is right, when these wells have been depleted and the 3 existing Noble producers have produced all that they can, Noble would like to come in and develop this as a 960. The difference in this versus Bonanza Creek is that we'll truly develop as a 960 and we'll be the majority operator. You know, the average AFE I get coming across my desk is 5, 10, 15, 20% tops. I don't see 70% AFEs coming across my desk very often. It's very rare here in the DJ. And, you know, we do have legitimate plans. This is a high priority area for Noble Energy to come in and to develop. We do have the infrastructure in the area, as Mr. Bolton pointed out earlier. And, you know, it's our leasehold. These folks need to live within their leasehold. If they went ahead and they permitted 1 or 2 Niobrara wells as their drainage calculations specified, Noble Energy would be in here today fighting this out and wasting everyone's time.
Great. Thank you. No further questions.
Mr. Willis.
Thank you. Mr. Marini, are you also familiar with Exhibit BB? And I realize it's outside what Ms. Jost talked to you about, but that's kind of an infrastructure exhibit.
Yes, I am.
All right. So that pipeline that runs to 25, that's just a gas pipeline, right?
That is just a gas line, as indicated as red on the map.
All right. So the wells right now, what do you do with the liquids now?
Currently, the liquids off the 3 producing wells are trucked. But for a future development plan, as we have substantial oil pipelines and gas pipelines in the area, that obviously would be pipe production down the road.
Are you aware whether or not you've negotiated right of ways to get to the infrastructure that you're talking about?
We've analyzed the area for future performance.
And then I just want to ask you a question about your development plan. You talk about the fact that development is imminent from your perspective. When is that?
Well, we don't want to be bullied by another operator into submitting permits. You know, we're going to do that in the next, I'd say 0 to 3 years. We'd like to get a little more revenue out of these existing wells.
Right, but you don't know when it's going to be, right? You're just speculating it might be 0 to 3 years, but it might even be longer than that. You just don't know. A lot of it's commodity price driven.
We are a $1 billion oil company. We do have long-term plans, Rob.
No further questions. Thank you.
One short redirect, Chair.
Certainly, go ahead, Ms. Jost.
Okay, and Mike, just back to the same point we made with Mr. Bolton. You as Noble in section 25 as 100% leasehold interest owner should control the destiny and the timing and the development of that leasehold, correct?
Correct.
Okay. So all these questions about why aren't you producing now, again, is that a red herring?
Absolutely.
Okay. And does Noble need to come in with additional APDs or an additional development plan to protect its assets that it has already invested in and produced?
As we've invested in it and it's currently producing today, no, I don't believe so.
Okay. And just a couple more questions. Is it your opinion that a majority of the EUR from the 6 existing wells in the west half of section 24 has already been produced and Bonanza has not shared any of that revenue with Noble?
Yes, and as these wells were excluded from the unit, we won't see any revenue from what's remaining down the road.
Okay, and is there, based upon several questions asked by the commissioners, are there more undrained hydrocarbons remaining in section 25 since there are only 3 wells in the 640 versus the 6 wells that have drained the entirety of the Bonanza 320?
There are more reserves remaining in section 25 to be had, and Noble has plans to get those down the road.
Okay, and yet again, Noble owns 100% of section 25, correct?
Correct.
Okay, thank you. No further questions.
Commissioner Boygan.
Thank you, Mr. Chair. I have a few questions here. You said that you are sticking up for the royalty owners and mineral owners in section 25 by keeping them from being diluted with the owners in 24, correct?
Correct.
But isn't a smaller share of something better than a bigger share of nothing?
I would agree, except that I don't believe it's a bigger share of nothing. We do have legitimate plans to go ahead and produce this rock down the road. I mean, as I mentioned, it's high quality DJ rock. It's right in our core asset. I mean, it's really in our medium to long term forecast. Absolutely.
I've heard you say that several times. I haven't seen any specifics. There's a lot of arm waving, and we've got a specific plan by an operator that's filed an application, and you haven't. So we're, I guess, taking it on faith that you'll get to it. Isn't the loss of acreage that you're talking about due to the fact that you would not participate in the wells that they propose to drill to develop the reserves that you admit are available in section 25?
Absolutely. So we just want to make sure I get this question answered right. So stop me if I'm doing this wrong, but you know, we do want to go ahead and get this produced. We don't want to participate in a Bonanza well. We don't think it's the right time to go ahead and take the 3 current producers we have offline yet today. The Bonanza Creek wells just don't perform very well. And you know, anyone can file a permit in Colorado, but it doesn't necessarily mean they're going to drill that well.
Fair enough. If I could, I've got a couple of follow-ups.
Sure.
We're here today considering a spacing application, correct? This is not a pooling application. It's not a Form 2. It's not a Form 2A, correct?
Jimmy, correct.
That is correct.
It's a rhetorical question, sorry.
Effectively, though, you have to look at all of those to determine the development and the proposed development plan by Bonanza Creek. So even though the Form 2, the Form 2A, a pooling is not up, your ultimate basis under 3460-116-2 is to look at the unit before you even determine the number of wells to decide, will it prevent waste? Will it protect correlative rights? Will it result in efficient and economic development? So even though no, we're not here on all those, the reason we as Noble had to look through all that is because that's the proposed development plan of the 1280.
Fair enough.
Thank you.
Good answer, Ms. Jost. So will you have an opportunity when the Form 2s are filed to weigh in terms of potential interference with your wells?
Mr. Boygan, if I may, or Chair Boygan, or Commissioner Boygan, Vice Chair Boygan, you have lots of titles. So the Form 2s are already filed, and I think there's a recognition by this commission that the process of an operator objecting, protesting to a Form 2 before it's actually approved is questionable at best for the processes that we're forced to act under right now. Mr. Bolton did testify to the fact that if these Form 2s are approved, they will object to them. If there is the ability to object and protest to the Form 2s prior to their approval, Noble will object to those as well. So even though that's the case, this should not be looked at as a Form 2 and 2A issue. It needs to be looked at as the actual establishment of the unit issue.
Can I ask one more question to Mr. Bolton or Ms. Jost? Not Mr. Bolton, I'm sorry, Mr. Marini. If, in fact, your wells are damaged, as you say they will be, would you expect to get compensation for that from Bonanza Creek?
So great question. So historically, you don't see compensation if your well gets fracked into. But really, if you're part of the project, if you opt into the new well, then the benefit is that you get brand new horizontal wells to compensate you for your loss.
Right.
Now, normally what I'm used to is if we were to drill adjacent to or through some existing wells, they'd be our own wells, right? We don't just go trampling through and destroying other folks' wells.
Their experience, correct?
Right. That's odd and foreign here in the DJ to me, in my experience.
I guess, Commissioner Boygan, I would also add that while the question is, would you expect compensation? The answer is, would you get it? And, would you get it via a commission process? No. Would you get it via a court process if they don't pay? Questionable. It really comes down to the fact that should never be a question. As a 100% owner in Section 25, Noble's being asked to destroy its own wells by participating in this unit. And so compensation aside, frankly, it's probably irrelevant for purposes of the establishment of a drilling and spacing unit, very respectfully.
Understood, Ms. Jost. But the commission could presumably condition approval of the wells, for example, on ensuring that there is no interference, number one, and number two, on arranging for compensation if there was.
I guess from that perspective, I would leave that up to whether that is actually within the authority of the commission to do as part of your order. I actually don't think that's part of a drilling and spacing unit order. That would probably come in a Form 2 and 2A. Right. And again, we probably should never get there because the presentation submitted today by Noble shows that Bonanza should not actually have the 1280 established before we even hit any of those questions.
Okay, fair enough.
Thank you.
May I?
Commissioner Overturf.
So I, forgive me if I'm, may not be using all the right words. But earlier in your presentation, you talked about how there was going to be 900 feet of waste because of the 150 setbacks on each of the existing Noble wells, right? So this is the existing Noble well. There's a 150-foot force field around it. And so Bonanza is going to come in and go like, and then go around and then come back and then keep going. Correct? Okay. So help me understand the claim that there's going to be 900 feet of waste because of that process with your position that by doing this, you're going to undoubtedly frack into this and destroy those wells. Doesn't it have to be one or the other?
Let me confer with Jamie.
While she's doing that, actually, you can't do this. You kind of come down and then you're back up.
Well, yeah.
You can't make that sharp a turn.
It's also not an arm, but
Actually, no. Actually, it's. Yeah. Right. We can get to deliberation.
So a great question. So really, if you traverse the wellbore within 150 feet, fracs go all directions here in the DJ. These frac radiuses do travel more than 150 feet. They will for sure absolutely hit our existing production, and those wells will be knocked offline.
I think, and if I may help him through some of this.
Yeah,
so Commissioner Overturf, where the 900, and again, maybe it's not an exact 900 number, but when you're looking at the traversing of the wellbores as proposed by Bonanza versus the location of Noble's wellbores, 150 feet are not aside, and this is where Davey testified that maybe this was just kind of a red herring in here. It may not actually be waste, but it might be inefficiency. And there's inefficiency of development when you have 14 wells, up to 20 wells, potentially crossing 3 producing wells, whether it's 0 feet, 15 feet, 150 feet, or 300 feet, you're still going to have inefficient production because it's going to knock those 3 wells off. And I think that was the ultimate issue that we were getting to with that, was whatever number you want to put in there, it still results in inefficient development.
And you're saying it's inefficient because of the impacts on this, not because this guy is going like this. Sorry, everybody on the webcast.
It could be a little bit of both.
Right.
What you mean by this is porpoising in the wellbore, and that does tend to lead to really bad well results here in the DJ. That's probably the technical term.
Porpoising.
But and that there's lots of studies about unloading horizontals that show porpoising hurts production. But really, the core effect we're talking about here today is not just that, but really it's the frac into effects.
So generally, is it Noble's position that the 150-foot default setback is insufficient and should be larger in order to prevent that it inevitably creates collisions?
Well, I think it needs to be fit for purpose, in my opinion. I mean, the 150-foot waiver, if it should be, protecting your wellbore from collision while drilling. It should be for proper noticing. But, fracs travel far further than that. I think it would be unwise to set that barrier further than that as a rulemaking down the road, as I think it could lead to a lot of waste here in the basin. Does that make sense?
Yeah, and if I may add just one thing to that, again, I think this goes back to the fact that the 150-foot does seem to be a red herring here, because even if you take the 150-foot aspect away from here, you have 317R, 317S. Those are rules that, everyone has to follow. Those are rules that were set in a rulemaking that provided technical evidence in support of those rules. To add to Mr. Marini's point, it's a site-specific and kind of an APD unit and well-specific evaluation that occurs. And so when you have a 150-foot setback or whatever, it doesn't denote or take away from the fact that Bonanza agreed and admitted that they're going to frack into these wells. So it doesn't matter what number you put on there. There's an admission by Bonanza Creek that you're going to have frack hits. And so I just want to make sure that we're not maybe going down a rabbit hole that may or may not actually be relevant to the fact at issue, even though it's a rule that likely probably needs to be taken a look at.
Okay, I have no other questions. Thank you.
Yes, Commissioner Ager.
So one of your arguments was, why isn't this a smaller DSU? And can you show me what a 960 would look like?
Absolutely. Mind if I use laser pointer? So can you see that okay?
Yep.
So, to me, what a 960 would look like is simply, it would involve section 25, and it would involve the east half of section 24. It wouldn't involve the west half of 24, as there's no plans to infill this. Even if someone did try and infill this, it's depleted rock. Trying to squish some wells in there wouldn't be very economic. That's truly a 960. And I think the reason that Bonanza won't go ahead and plan this as a 960 is as Noble would when we get our shot at drilling this. Truly it's because their working interest is so minuscule. And by pooling in this west half acreage, you can kind of get away with abusing the commission rules. And you can inflate your working interest by pulling that in. And I think that's the game they're up to.
So if this was a 960, would you still object?
Yes, I would.
Because it would damage your wells.
It would damage our wells, and actually we would have an even higher working interest in the unit that we don't want to participate in.
Thank you.
Yes, Commissioner Jolly.
Can you explain, and maybe I'll have Bonanza also, but why they're not proposing any more wells in the west half of 24? Or why you don't think it's doable? I must have missed that part.
I would punt that over to Bonanza Creek.
Okay.
Yeah.
Answer that. Go ahead, Mr. Willis, if you'd like to
Yes.
answer that again.
You know, could, and Ms. Lehman was the one that addressed it, I believe, during her testimony. And I believe it's commodity price driven to some extent. We've analyzed that as a development team right now and feel that, you know, this for the near term development plan that we have, it includes developing the east half of the sections coupled with the west half of section 25 right now. But it doesn't mean that we wouldn't go back, or it doesn't have to be us. It could be anybody that's an owner within the drilling and spacing unit. If the application is approved, they could drill through that rock as well and drill that. So, I mean, it's just, it's somewhat complicated by the depletion, but there's been depletion in section 25 as well by the producing wells from Noble. But I would just say, and I think this characterizes Ms. Lima's testimony, and correct me if I'm wrong, Ms. Lima, but it's just in the near future, it's not what we're concentrating on right now. It's developing part of our leasehold in the east half of 24, coupled with the lands in 25, which is done all the time by drilling and spacing unit application. We're looking for nothing unusual or something that's not typically approved by the commission.
Commissioner Jolly, if I may, with respect to the statements that Mr. Willis just made about another operator coming in with the interest in the unit and then developing that west half of section 24. You can see that there are 6 wells already there. You have already heard that Noble is not going to come up and develop acreage that it does not have an interest in. And you've also heard Noble say that if they're going to do any type of development or changing of wells, it's going to be on their own. Noble is not going to get in a situation of developing the west half of 100% Bonanza Creek's interest and come in and have the allegation that they have then destroyed those 6 wells. So I think that the statement that was made is not part of this development plan. What you've seen is the development plan on the screen. And you've heard Noble's testimony that development plan does not support the act and will actually destroy Noble's wells and interest. Thank you.
Mr. Chair,
Commissioner Egger.
I'd like to follow up on that, although it's for Bonanza Creek. Is that okay?
Yes.
So my question is, I hear what you say about your development plan, but help me understand, because what it feels like is that you're avoiding damage to your existing wells, but it's okay to disregard Noble's existing wells. So explain to me how that's different. How
Perhaps Ms. Lima might.
It might be better for Ms. Lima to answer that instead of me jumping around.
And I guess a clarification is that we're not infilling wells in section 24 to avoid damaging existing wells. And there was some information that was presented earlier that wasn't quite accurate. We do have horizontals in section 24 that were drilled in 2012, and the verticals in section 24 actually predate 2012. So there is more drainage calculation in section 24 than there is even in potentially in section 25, with 3 horizontals. And as stated by Noble, 1 was a 2010 vintage and 2 were 2012 vintage. There is also some vertical wells in section 25 that are no longer producing, or according to the state website are not producing. And so our section 24, because of the number of wells in that section and the age of the wells, there is more drainage that we're calculating reserves already produced. And so given the current price commodity, from an economic standpoint, at a $50 oil environment, this is not the right time to come in and capture additional reserves from section 24. It is not because we don't want to damage our own wells.
Okay. And can you explain the difference between the 14 wells that are proposed and the 20 in the application? Would those 6 go in the west half of 24?
It could be in section 24. It could also be Codell wells. So that is, again, There's so many things that change. I mean, technology changes, the price environment changes. And so there is opportunities to reoccupy our pads in the future. And just like Noble has a plan to develop Section 25 in 0 to 3 years, it could be 0 to 3 years. The wells in 25 have been online 7 to 9 years at this point. And so if the opportunity to reoccupy existing sites and add wells, and again, I don't have the ability to look into the future. So depending on technology at the time or the price environment, there are certainly, we call them slots. There's places to 37, if 37 acres is the drainage around a Niobrara, then 3 horizontal wells in a 640 acre section does not adequately capture the reserves in that acreage. And so we do have additional slots and we will have the facilities and the infrastructure that we can always add more wells and improve the recoveries. And we calculate all the time what is the recovery, even on 16 wells per section, it's still very low. So as long as we can economically add wellbores, and now the technology to drill those wellbores, we can avoid them. And the rule is the 150 setback was the anti-collision setback, not the not frack into setback. So we can now, with drilling technology, infill our sections and avoid existing wellbores.
Yeah. All right. Thank you.
So before you go, Ms. Lima, I didn't know, did you have something else?
Thank you. Yes, may I?
May I ask her a question first?
It's for her too.
Okay. I noticed in this that there was only one Codell well over on the far west side of the proposed DSU. I think you may have answered that, but I'm just curious why there weren't any other Codell wells as part of this spacing application.
It's kind of light technical humor that there's some people in our company that love the Codell. I love the Codell as much as the next person. But the Niobrara package of available reserves is much, much thicker when you look at the Niobrara. And even though we land a well in the Niob, you know, there's theories and models that there's also some contribution from the C and the A. And right now, the work that we do, we are optimizing both the recovery of the section and also the rate of return of the individual wellbores. And given the technology that we work with today, and the Codell is a much thinner reservoir than the Niobrara. And so the 16 wells per section, the higher density, the rate of return that we're modeling is higher on the Niobraras in the slots in the inside of the spacing unit versus the Codell well.
Okay, Mr. Jolly.
Were the producing wells in the west half, what spacing were they paid out on? Was it a 320?
Yeah, if I could, one of the wells is on a 320 basis, I believe, and under a spacing order. The other wells are on the wellbore spacing unit development plans, and I think both those are. It's either 160s or 320s, wherever the lands, the quarter sections within 460 feet of the wellbore.
So the west half of section 24 has been paid, the mineral owners in that part have been paid quite a bit just for the west half, and now they're going to enjoy splitting the whole 1280. It just seems like there's an inequity there.
I don't know if we're going to open up that book for purposes of the spacing application. You know, I understand what the commissioner's concerns are with regards to that. You've devised rules now which allow operators to come forward for drilling and spacing unit in GWA, which basically are overlays of existing development orders, whether they be through wellbore spacing units or other development plans for like 1 mile laterals, which is what we see here for the one well that's paying out for the west half on that 320 basis. So I mean that's just something that we deal with and the commission deals with and staff deals with on a daily basis. If these lands are going to be produced while protecting correlative rights and preventing waste.
Okay.
Well, Ms. Lima, one more question. You mentioned something about the thickness of the Niobrara package here. Roughly how thick?
200 feet?
About 200 feet. Okay. So it might be a bit of a challenge to sort of float under the existing well bores and stay within that range if they're already in the sort of in the mid range of that 200-foot section of the. I'm talking about the 3 Noble wells.
Well, the setback is the producing interval, but there is still space beyond. You have the Codell as well. So not just the Niobrara package, but it's still very possible to avoid by 150.
I understand that. It's just, can you stay in your Niobrara section and still be able to avoid those wells? So that might be potentially an issue.
Right.
Well,
It might be an issue. And like I said, there'd be a development order that we need to stay 150 feet back.
Yeah.
If we can't, we try to get a waiver from the affected operator. And if we can't get that waiver, we could even choose not to complete that part of the interval that encroaches upon the 150 feet.
And the drilling technology that we use today does enable us to have that kind of precision.
I understand that. Yeah. So you can thread the needle at 9,000 feet. Okay, thank you. Yes, Ms. Joes.
Chair Pitton, but just to address your question on that as well. I think with respect to the thickness of the interval, there's still the fact that needs to be considered by this commission that if Bonanza wants to do that to its own wells, that's something that they should consider. But when this is with respect to Noble's 3 producing wells, and there's a concern about basically the leftover footage, that should not be allowed for purposes of the 100% leasehold. Thank you.
Certainly. So I have some questions for Mr. Marini, but I'm going to make sure that there aren't any other commissioner questions. Very well. First off, your exhibit B has come up a couple of times. And what we can see from that is there's a gas line that goes into 25 that I'm assuming is owned by your midstream company.
Yes, all pipelines on that map are owned by Noble and Noble Midstream.
Okay, and so you said this is a core asset and you had lots of infrastructure. Is there other infrastructure out there that does not show on this map?
Yes, sir, absolutely. In fact, we've got a plant, a central processing facility to the north and west of here, not too far away. And that's where all those lines head to.
Not too far away. Let's be specific. How far away is not too far away?
Let's say all those lines head to it. And those lines, I wish I had a map in front of me, but within a township and a half.
In a township. At the moment, though, between the gas or the oil lines you have over there in section 21 and 22 down to the section 25, you have no pipelines.
Correct. We don't have pipelines within 2 miles, but this is not populated, east of Greeley. It's farmland. We haven't had issues with getting right away or SUAs in this area. I was looking at an aerial map here today. It's pretty quiet out here.
At the moment, the only surface use agreement you have with the owner right now governs your 3 producing wells.
Yes, that is correct.
Okay.
We have found some alternative options that are available, and those are being discussed.
Okay. And you mentioned again that this was considered to be one of your core assets.
Yes.
So following along with that, if we look at Bonanza Creek's Exhibit 18, essentially, and I believe you've testified that you have 100% working interest in Section 25 and 100% working interest in I believe a 160 in the southeast of Section 24.
No, we have the majority of the interest in the east part of Section 24. Bonanza has a small federal lease of 60 acres on the north side, I believe, and we have 125.
Okay. And so what I'm struggling to try to understand is that when you testified, it says you're $1 billion oil company, how roughly a section and a half can really be a core asset, particularly when you think about your CDP that you're developing over in the Mustang CDP. So help me understand why you consider this a core asset when you're $1 billion company and it's a section and a half.
Yeah, happy to answer that. So the CDP is a great project for Noble, but we don't maintain 100% of our drilling rigs in that area. We drill other areas, the Northeast Wattenberg extension, We drilled this area just a little bit to the north and west of here. This is all tied to that. As you can see from the pipeline map, we do have infrastructure hooking into this within a few miles away. You know, the CDP is not 100% of Noble's future plans for the next 3 years. We have other assets that we are actively permitting and pursuing plans in.
Which you've mentioned this, that currently you have no specific development plans, but maybe something happens in 0 to 3 years.
I would say that with a GUR of 4 and this being trophy Niobrara rock, we would be silly to not want to produce this ASAP. And this is a high priority for us in the next 3 years.
Sort of leaves me believing you already should have a development plan in place for this area. Going back to your comment about plugging the 3 wells, I'm curious about what rule in our rules and regs would require you to plug those wells.
Sure, good question. The reason for plugging these wells is because the chance of us resurrecting the production or resuscitating these back to life, swabbing on them, cleaning them out with a coal tubing rig or service rig, the chance of success on that is ultra low. It would be expensive to do. The cost of a project to try and explore, if that were possible, would be paid for 100% by Noble, as Bonanza has no ownership of the wells. We know that the chance of success on this is so low that the only prudent option is to go ahead and plug them.
So that implies to me that you've actually studied that and looked at the chance of success of this. And so could you share that information basin-wide? What's the chance of success of resurrecting these wells? And is that something that you can provide?
Absolutely. So basically in the frack into game, you know, if you frack into a well that the 2 wells are parallel to each other and they're spaced 600 feet apart, you've got a pretty good chance of getting that old well back online. And it's not uncommon to take an 80 or 60 or 50% cut in production, but you know, you can get those wells back in line. But you know, the case history of this, where you're hitting it perpendicular and you're hitting it 14 times with 14 different wells, we have not had a successful case that I have seen at Noble Energy where any of these wells come back online. And I would consider this a worst case scenario in the frack hate game.
Okay. All right. Interesting, you talked about the $40 million cost and the existing gross revenue. I'm curious about whether or not you looked at this from the standpoint of what about, and that's 70% of the cost. You also get 70% of the value out of this, and what's the potential economics? Because I would think with a development plan where Bonanza Creek already has existing infrastructure, that their operating expenses would be lower than running just 3 wells sitting off by themselves. And if you looked at the relative change in economics from doing that and participating in those wells on that basis.
Great question. And yes, I've actually looked at Bonanza Creek extensively as it relates to this section and their broader operations. They do have some pretty low well costs. Their own staff have admitted that they're probably dated well costs from older oil prices, pre-bankruptcy, stuff like that. But, you know, I would expect them to have some lower well costs. But generally, they'll feel, you know, you kind of get what you pay for. The Noble wells would cost more, but you get far better benefit. And I think in my slide pack where I showed that we see 40% better well performance, we truly would get better well performance, in my opinion, out of a Noble Energy project. And you know, the proof's in the pudding here. I mean, historically, we've tried to find farm out partners to take some of the smaller AFE packages we've gotten from Bonanza Creek. They're a challenge to find. A lot of the industry has also shared my opinion with this.
Which I get that part, but what I was asking about is, did you look at a difference in operating costs because they already have an infrastructure in place and you're going to benefit from that, compared to where you have no infrastructure and anything that you develop out here is going to have to bear the cost of that infrastructure?
Absolutely. So, you know, infrastructure wise, it's a pretty small part of the AFE bill. The majority of an AFE is 60 or 70% completions. So that small increase in infrastructure costs that Noble would have to lay down additional pipeline is probably not a huge delta in the economics, is my opinion.
Having managing a current operator's midstream business, I will have to disagree with that. It is not inconsequential. I think that's all I have for now. Thank you. Ms. Jost, is there more folks?
We have no further witnesses. Thank you.
And may we have a time check for, nope.
Yes, for Noble, there is 17 minutes and 3 seconds. And for Bonanza Creek, you didn't ask, but it's 17 minutes and 6 seconds.
Very well. Oops, I was in the wrong place. So, Mr. Roush, we haven't had any 510 statements, so is there a staff analysis that went with this?
There's no staff analysis.
All right, so we'll move on to rebuttal by Bonanza Creek.
If I could, I'd like to call Ms. Lima back to the stand. She's already here right now.
Absolutely.
You were, Ms. Lima, you were listening when Mr. Marini talked about the results that Bonanza Creek gets with regards to their operations in contrast to Noble. Do you have any kind of reaction to that?
I do. Bonanza Creek drilled the first horizontal well in 2010. And over the 9 years now that we've been drilling horizontal wells, technology has changed. Our understanding of both the subsurface and completion design has evolved over that time. And we are now, we did go through Chapter 11 in 2017. That is our story. We're not by no means hiding that piece of information from anyone. I wish that we had rebranded through Chapter 11, but we made an economic decision not to do that to our shareholders. It's very expensive to rebrand, especially if you're a publicly traded company. But we are now a new Bonanza. We're a different management team. And as Christina mentioned, we use public data and we use large data streams, and we run proprietary analytics within the company to figure out with our factor inputs how much we pay for our materials to drill and complete our wells, what is the optimum completion design to maximize on the rate of return. And we're also looking very closely and studying our oil recoveries, both on a wellbore basis, on a spacing basis, and on a per section basis. And it's very proud for me with my Bonanza history that on January 14th, a third-party company, anybody, I can cherry pick a set of wells and I can show you that I'm a better operator than my neighbor. But what is most important is when there is a third-party impartial analysis of two operators or of operators in the basin. And recently, a company called RS Energy did an analytics report of the DJ Basin, and they looked at only wells from 2017 and 2018, which enabled kind of level set all the companies. Everybody has history. They would have liked to do wells differently 9 years ago. We all have those stories. But looking at only our most recent wells, level setted us in terms of, given the current team, current thinking, what is the current results? And given that data set, we were on par with Noble. So in terms of oil recovery on a wellbore basis, and this was normalized to 1,000 feet because our single mile lateral, the actual completed lateral length is not exactly a mile, and it's different for every company. And so what the third-party companies do, the analytics companies do, we normalize to 1,000 feet, which is a way to normalize the data set, and we are on par. So yes, if you look at some set of our wells, some subset of our wells, I'm sure that Noble's wells will outperform us, but I can also look at a subset of wells and find a set where we outperform. And it's like reading an investor deck. There's always you're telling a story, but when a third party impartial company compares companies and we are on par, that is a very trustworthy data point.
I have nothing further. Thank you.
Very well, Ms. Jost.
No cross. We think it was just a restatement of what was already provided by Ms. Lima earlier. Thank you.
Okay. I think, would you like to provide any rebuttal?
No, not at this time. Thank you.
All right. At this point, we're up to closing statements. So Mr. Willis.
I appreciate it. I'll try to be as concise as I can and short. I know the hour's late. This application brought by Bonanza Creek is a typical spacing application, something that you see hundreds of times throughout the course of a year if you're the commissioner. And there's really not a substantial deviation from that. These nominated lands exist on top of wellbore spacing units, as well as existing spacing orders from legacy wells, from older wells that have been drilled. And what this recognizes, this application, is the mere fact that 2 milers are what is the Cadillac for this part of the world, right? And you look and see what the application is from Bonanza Creek, and you hear their testimony, and they talk about the infrastructure that they've brought to this hole in their development plan. And I submit to you that that's compelling as to this particular piece of the puzzle would fall into place should this application be approved. The application calls for the establishment of the 1,200-acre drilling and spacing unit for the Codell and Niobrara formation from sections 25 and 26 of 5 North, 63 West. It also requests the authority to drill 20 new horizontal wells and honoring setbacks, which are familiar with all those applications that you see all the time. 460 feet from the proposed unit boundaries, and you also heard testimony that even that 460-foot gap between or surrounding the proposed unit boundaries is subject to 318A horizontal well development too, and you've heard of steps that are taken by Bonanza Creek to make that happen, and that's consistent with not just their infrastructure but also their negotiation with 70 Ranch and the surface locations that are in place right now that can take this type of development and these number of horizontal wells. Just a quick review of the expert testimony. Max Faith described his experts at engaging Noble. Those were fruitless. And I submit to you that your questions to Noble, I think, were spot on. I mean, this is an operator that doesn't want to have Section 25 developed by themselves or by another operator. It doesn't fit in their plan right now. And however, if Bonanza Creek were to get approved application and get the permits in place and drill the wells, they would be accountable to Noble at 70% interest was the testimony, and Noble would be entitled to 70% of production from those new wells, and I think it's important not to lose out on that. Or not to lose that in the testimony. There's discussion about there's talk about the disruption in the existing Noble wells, and they're going to be impacted. Yeah, I think they're going to be impacted. They may not lose those wells. They may come back, right? But those wells are in the latter part of their life. They've been on since I think 2012 or 2010 was the testimony. So they're older vintage wells. And they're going to be replaced with these new wells that Bonanza Creek would operate. And of course, once again, a Noble would be participating in, or at least have the opportunity to participate according to the rules. So once again, Max Faith talks about the land piece and what's been done. That they have, Bonanza Creek has ownership within the application lands. It doesn't have to be majority interest. It has to be an ownership interest. And I think based on the testimony that you've heard, Bonanza Creek has justified their plan and why the plan is attractive to them and valuable to them. And I submit to you too that it should be valuable to Noble. And it's going to be up to them to decide whether or not they want to participate should development occur under the approved application. This regional area is a heavy focus of Bonanza Creek's legacy position. There are 2 large landowners that they've been working with, whether it be 70 Ranch or whether it be the state land board, to kind of put the facilities in place to where they can move the product out of an approved application area and to get the liquids out as well as the gas. And you heard Ms. Lima talk about the state-of-the-art infrastructure that's at that surface or at that central facility with regards to VOC emissions, and the fact that they are state-of-the-art with regards to CDPHE compliance. There are also oil and gas right-of-ways which exist under the SUA. Mr. Faith talked about that. The existing road corridors are optimal to get the product out of the drilling and spacing unit onto the central facility. Mr. Schroeder talked about the geology of these lands. You've seen it time and time again that these lands produce hydrocarbons from the Codell and Niobrara formations that Bonanza Creek has, you heard him testify that they've successfully stimulated 30 horizontal wells across existing horizontal wells with minimal impacts to those existing wells. Ms. Burnett talked as a reservoir engineer primarily and talked about the number of wells being the right number. What's requested, the 20 wells, is the right number to develop these lands, given the price environment right now. And she also talked candidly with the rest of the team about the west half of 24 and you know that area of the drilling and spacing unit is not depleted fully. It does have some value to it, and there'll be a time, hopefully in the future, sometime when they'll infill there as well. And it doesn't have to be Bonanza Creek again. It could be a third party operator. It doesn't have to be Noble. It could be somebody else that acquires interests within the drilling and spacing unit. But this application is just our near development plan and what we're looking for authority for now from the commissioners, so we can get the drilling and spacing unit approved and then get the APDs eventually approved, so we can start extracting these minerals from the land. You know, and what I'd like to just kind of finish up with in my closing is, you know, Noble makes it look like this is something that is forbidden as under the Oil and Gas Act, and nothing can be further from the truth. This is what happens all the time with regards to establishment of drilling and spacing units. When you have an interest within those lands, and you come before the commission and request that a unit be established for production of oil and gas of a certain pool. And you've done this time and time again. I've been in front of you for adjudicatory hearings where you've wrestled with this issue, where you've had an operator who has a stake in lands that are adjacent to another operator who has 100% of whether it be a quarter section or whether it be a half section or whether it be a full section. You've recognized that the company that comes before you with an application which meets the criteria of the Oil and Gas Act, which provides testimony that approving the application prevents waste while protecting correlative rights, that application gets approved. And historically, that's what the commission has done, whether it's a case that I had 3 years ago in Gunnison or another case that I had involving these same operators up in Sterling, Colorado, I think it was a year and a half ago. Similar types of objections were made by Noble with regards to protecting their acreage, is how they said it. But they basically just didn't have a development plan for it, and we were in there with a development plan. And so the commission analyzing things and looking at the evidence and recognizing that they have an obligation to approve that application. They approved that application. Even on October 30th of 2018, there was an adjudicatory hearing, and I'm talking about order number 407-2619. It involved Extraction and Synergy as the protestant. The commission took similar facts and established a 1280 drilling and spacing unit for extraction because they were compliant with the Oil and Gas Act. And the order from that case said that the commission found that the Oil and Gas Act requires that an approved spacing unit prevent waste, avoid the drilling of unnecessary wells, and protect correlative rights. Another finding that the act authorizes the commission to divide a pool into zones and establish drilling units for each zone, so the pool as a whole will be efficiently and economically developed. There was only one development plan at issue on that day. The protestant did not have a competing application, which was duly noticed for that hearing. The commission approved that application. The Bonanza Creek application here is on par with that approved application and hundreds of others that you've approved, whether they're on the consent agenda or other adjudicatory hearings. I believe that Bonanza Creek's witnesses are credible, and they provided expert testimony showing that approving the application conforms with the act and that it will prevent waste, protect correlative rights while avoiding the drilling of unnecessary wells, which is economic waste. Bonanza Creek has successfully worked with the surface owner, who is also a leased mineral owner, when devising the development plan for this acreage. Bonanza Creek has pending APDs in the queue that are waiting on the approved application. It's in their plans to do this, certainly within the 2-year term of an approved APD, but you've heard testimony likely that it would occur by the end of the year this year as they get going on that. So, my last remark is just that this is an occasion by Noble basically coming before you and saying, we've got a majority interest position here, and you can't do this under the Oil and Gas Act. And if you, the commissioners, approve this, you're suborning an abuse of the Oil and Gas Act. Well, that's nothing further from the truth. Or what we're trying to do is trying to develop our minerals in conjunction with Noble's interests there. And to do that, we need to come to you to get approval of this drilling and spacing unit, which is the only thing before you now. So that's where we're at. We're requesting that you deliberate on this and that you approve the application so we can get on our project. Thank you.
May I have a time check?
Yes, Mr. Willis has 1 minute and 32 seconds.
Well, you're fairly efficient on that.
Thank you.
Nicely done. Ms. Jost.
Thank you, Chair. Again, thank you for your time today and your consideration of this matter before you. As you heard in my opening, the three-legged stool cannot stand, no matter how hard Bonanza tries to finagle us and call it a typical spacing application. Also, as stated before, we are here because this is not your typical joint and spacing unit fight, as you have seen recently, even though Mr. Willis and Bonanza would like you to believe that. The lands are not virgin lands. The lands are not subject to competing speculative future development plans, like you've heard in the orders that Mr. Willis just described to you. What you have here is another operator attempting to usurp Noble's assets, interests, and acreage in a 100% producing economic wells lands in Section 25. Noble has provided substantial evidence to support the fact that the three-legged stool cannot stand through its testimony today, and has in fact provided well more evidence than just majority should win, as characterized by Bonanza Creek throughout this hearing. If the application is approved over Noble's objections and Bonanza's own admissions, inefficient development will immediately be approved in violation of the act. Waste will result, even though this commission must prohibit waste. Noble's correlative rights and the interests of its mineral owner will be harmed and taken, even though the commission is given the ability to protect those interests and to protect against inefficient development of hydrocarbons. Bonanza Creek has not met its burden in this case. In fact, Bonanza has done nothing but provide generic testimony without giving 1 ounce of credence to the fact that it will not only interfere with, but will destroy another operator's 100% existing producing wells. Well, it owns 100% of the leasehold interest. They're basically asking Noble and this commission to just trust them when they decide to how to actually drill the wells. And then they're actually asking Noble to fund 75% of the cost of that development and 75% of the cost to destroy Noble's existing 3 producing well bores. Noble does not need to have a competing plan of development to continue to develop their 100% interest in Section 25. Noble does not need to have an additional surface use plan in place for the continuance of their 100% development in Section 25. Noble does not need to have an imminent development plan for its 100% interest in Section 25 to defeat Bonanza's unit, where Bonanza would only have a 60-acre federal tract in the unit without the inclusion of the west half of the 320, or the west half of Section 24, 320 acres being included in this unit. There is not a requirement or rule that requires a competing unit to be filed in an operatorship agreement. nor should it be required to defeat an inefficient, wasteful, and abusive Noble's Cradle of Rights development plan in an unsupported 1,280-acre unit. 1 year, 2 years, 7 years, 9 years of Noble's well production, it doesn't matter. Bonanza Creek does not get to control the development or destruction of Noble's own wells, of Noble's 100% leasehold interest or Noble's acreage. Noble's mineral interest owner of the 100% lease, one lease on Section 25, would be the only other person or interest owner outside of Noble to control the development of Section 25. And that interest owner has relied upon Noble to be here today to protect its interest from the proposed inefficient 1,280-acre unit proposed by Bonanza. Bonanza admitted that its development plan will cause frac hits to the wells. Bonanza admitted that the Bonanza 320 in the west half of Section 24 is even more drained than the Noble 640-acre tract. So including that further dilutes Noble's interest and harms the mineral interest owner. Those 320-acre mineral interest owners have been paid out. Noble's have not on that 320. And this, in fact, will harm Noble and its mineral interest owners' relative rights if that 320 is included in the overall 1280 as asked by Bonanza today. Further, Bonanza has done nothing to show its intent to develop the wells other than file APDs for 1 mile laterals that are poised to produce almost all of Noble's leased interest in the west half of Section 25. Bonanza's failure to file any federal permits in the east half of 24 and 25 also illustrates the fact that Bonanza does not intend to develop the entirety of the proposed unit and is seeking to develop the 1 mile laterals to take Noble's 100% right to develop the west half of Section 25 away from Noble to the harm of Noble and its mineral interest owner. You just heard Mr. Willis state in his closing that the 2 mile wells are the Cadillacs of wells, yet Noble holds over 75% of the leasehold interest in those proposed 2 miles. And again, if approved, Noble would be forced to fund the program of another operator whose wells are 40% less productive than Noble's, or would be completely out of those wells until 200% payout, even though it owns a 75% interest in the east half of Section 24 and a 100% interest in 25. This is unacceptable and should not be allowed. Mr. Willis just stated that the approval of this 1280 is not forbidden by the commission or the act. The approval actually would be forbidden by the act. In addition to showing that the three-legged stool cannot stand, that waste would be created, that correlative rights would be harmed, and that unnecessary wells would be allowed, the commission can also find, based upon Noble's substantial evidence, that the proposed drilling unit itself will not develop the pool of hydrocarbons efficiently as required by 3460-116-2. That is your statute that you have to look at when you're establishing a drilling and spacing unit. It also, you as a commission could also find that the number of wells proposed will result in unnecessary wells and will immediately create waste by destroying Noble's wells, and under the other definition of waste, would allow Bonanza to abuse the correlative rights of Noble. That is waste under the Oil and Gas Conservation Act as well. For the reasons presented today, Bonanza Creek's application should be denied. And thank you again for letting us present, and we'd be happy to answer any additional questions you may have. Thank you.
Any additional questions, commissioners? I have one. Of the 3 wells that you currently operate, what's the remaining recoverable reserves for those 3 wells?
Those wells each are about 200 to 300 EUR wells. They're in the Niobrara B and C. They're likely to be 70% depleted as we did bring those things online back in 2012.
So the EUR is between 200 and 300,000 barrels equivalent?
Yep.
And you say they produce 70% of that?
Yes.
Okay, so if I do the math right on that, that would be roughly 60 to 90,000 barrels equivalent left.
Yes.
Thank you. Hearing no other questions, I believe the next step here is to close the record and to deliberate on this matter. So we're prepared to close the record. Very well, let's close the record. I'm interested in your comments, but I was going to lay a few things out first, since there seems to be some technical things here that a number of things that concern me. And if you look at Noble's PowerPoint, which is sort of the three-legged stool: avoiding drilling unnecessary wells, preventing waste, and protect relative rights. So things that I think is interesting in this is in terms of the loss of value, that sort of the key things that they stood on was a value of $15,000 an acre, yet there was no supporting documentation. It was just relying on the testimony of a witness. But previous hearing, we had several pages of average costs. So we're essentially supposed to take that on faith that that's the current value. There was no net present value calculations for the existing wells, for the remaining, or whether or not there would be value presented by Noble participating. And they just assume and says, well, we're not going to participate because we don't want to spend 40 million. And then we go on and say, well, we're $1 billion company. So, where does that 40 million fit with that? They mentioned that we're asked to trust Bonanza Creek on a number of things. We're also asked to trust Noble on the acreage cost and destruction of wells. They pretty much said, oh, it's going to happen, yet there wasn't any, and said, oh, there was a study, but there was no evidence presented to that effect. So that concerns me about those pieces. So I sort of get to, it may not avoid drilling unnecessary wells, and it may not prevent waste because it seems to be a fairly efficient development. What concerns me, and I think Commissioner Boygan brought this up a couple of times, a couple of different ways, and I think also Commissioner Hawkins, is protecting the correlative rights. And I struggle with that because it appears that that east part of 24 is pretty far at the end of its life. Noble stated at the end that the original wells were 200,000 to 300,000 barrel EURs. I haven't done the math, but that's roughly 900,000 barrels recovered out of that one section 25. There's obviously a fair amount left there. So I think where I struggle with is, are we holding up all three legs of that stool, or are we missing one? So I would invite any other commissioners' comments based on that. Commissioner Hawkins.
Well, the glaring issue to me is the west half of section 24 already been developed substantially. And
sorry, west half, yeah.
Yeah, west half.
Yeah. Thank you.
Part that's already got 6 wells in it, and if it needed 2 more or 3 more, they could be developed from the existing site, and it would not affect any of Noble's acreage. But including that west half of 24 in the proposed spacing unit, I think dilutes Noble's interest of their remaining reserves. I think it is a violation of correlative rights. And without including that, Bonanza Creek hardly has anything left in the rest of the area. They've got 60 acres up on the far north end. So I have a lot of concerns about protecting correlative rights. I don't think this is a typical spacing unit. I mean, we've got too much development that's already occurred on the west half of 24 that makes this be more unique than just 2 competing operators. In my opinion, a 960 spacing unit would have been more appropriate. Exclude the west half of 24 and let it stand on its own. And whether it's Bonanza Creek or Noble, there's testimony both ways. I'm a little indifferent to that. I mean, I think Noble has definitely the bulk of the equity here in that 960, but regardless of that, I think that would have been the more efficient way to develop the remaining reserves out here and not include the west half of 24. That just skews the equity and takes it away from one party and gives it to another. So
I think the difficulty is that Bonanza Creek clearly has the infrastructure to develop this more efficiently. So they already have the facilities in place, gathering lines in place, things that reduce VOCs. So in terms of efficient development of this area from a standpoint of
well, and I don't have a
waste
problem with that. I think if it had been a 960 and they had proposed it, it might have been slim, looked like, well, they barely had an interest, but
yeah,
we could have considered that as a little bit more of a.
Yeah, it's this area where to me, it's a little bit of a stranded asset for Noble because they don't have anything else around it. Now, granted, they've got great working interest in Section 25 and a portion of 24, but they don't have the infrastructure. They've got a gas line that's owned by their midstream company.
Well-
And they've got to lay in oil. If they're going to do any major development here, it's going to take additional surface use agreement, additional rights of way, working, essentially, they're going to have to come back here again with a proposal for some DSU that looks like this. And where Bonanza Creek already has the infrastructure in place. It's unfortunate that the two parties couldn't have gotten together and worked something out here. You know, whether it was to essentially buy Noble out, you know, was left with that reading through this, and it's unfortunate that they couldn't have come up with that to acquire their interest.
I think where I'm coming from, that I think the proposed unit, the way I look at it, looks like it does not protect correlative rights. And so I have some significant issues with that.
Okay. Other commissioners? Commissioner Overturf.
I agree with Commissioner Hawkins, and I think that at this point, I don't think that I can support granting the spacing unit as it's been proposed. I think in part, this is a problem with advancing technology and a statutory and regulatory framework that has not caught up to it. And the realities of drilling today, when combined with our existing statutory framework, means that an operator can essentially carve out a spacing unit without, there is no sort of underlying pool. And so that can lead to sort of what appears to be gaming that's occurring here with the inclusion of that west half that arguably should have been excluded, and I think leads to the impact on correlative rights. I also agree with Noble that this is unlike some other disputes that we've seen before us, in that there are not really competing development plans that are proceeding on a similar timeframe, but rather there's development and there's production that's already occurring. And we're really asking, what Bonanza is really proposing is to come in and redo a lot of that while there's still active development and active extraction that's going on in that section 25. To me, coming in and creating a whole new set of wells and a whole new set of infrastructure in section 25 when the existing infrastructure is still productive and working is not efficient. And so I think that's another reason why I tend to lean against granting the spacing unit. But I did want to say that I did find the witnesses that Bonanza Creek put forward very compelling. And it seems as though they are doing good work in this region, but it's just the sort of specific facts that I do not believe. Again, it's not, to me, a choice between two operators and which one should have the authority to go forward, but rather is about, does the proposal that is before us, the single proposal that is before us, meet the statutory criteria? And I don't believe that it does.
Thank you. I was just a comment that you brought up. I wanted to mention about that. You said there is existing development in section 25. One of the risks associated with continued development is further depletion of that section. So they may be actually creating waste by not developing that in a reasonable time frame as they continue to deplete the reservoir pressure in that section.
These are one of the things that changes over time, and I recognize you may have a different opinion.
Yeah, no, that's a risk that we are considering here. Commissioner Ager.
And I think that leads into where I stand, because as I listened to testimony, I found myself trying to go back to what we normally do, whose plan is better, because I was focusing on the waste. And I think we're back in that situation where we're guessing, because we don't, right now there's some production in 25 that could be replaced later by Noble with better production, or there's marginal production now that will be replaced by something slightly better. But we're back to, we're not really sure, and we have two competing applications. But I think the difference in this is, I recognize we don't have an application, but it is the fact that we have existing production, which is different. And that leads me back to the correlative rights as well. When I look at the definition of the three-legged stool and we talk about correlative rights, I look at abuse of correlative rights of any owner in a pool due to non-uniform, disproportionate, unratable, or excessive withdrawals causing unreasonable drainage between tracts of land, and that kind of leads me more towards understanding Noble's position in this.
Fair enough.
Oh,
Yes, Commissioner Boygan.
I share some of the concerns that have been expressed. My primary concern about the application is including the west half of 24. That does trouble me. But I see what's going on a lot differently than my fellow commissioners. I think that Noble's sitting on the section 25 acreage with marginal wells, essentially using old diagonal wells to hold hostage any additional development. They're not going to be developing that acreage. They don't have any existing plan to do it. It's not primary for them. They're surrounded by Bonanza Creek. All the yellow on that map that Bonanza Creek showed us shows that this is a core area for Bonanza Creek. They've got the infrastructure, they've got the surface agreements, they've got the locations ready to go. They show a number of wells to be drilled in section 25 that would further develop the resource which Noble is leaving in the ground. So yes, it's true, this is not a typical situation of competing plans, but I don't view that as a plus for Noble. I see that as, in fact, a reason for granting the application because you've got an operator that's willing to develop that resource. On the other hand, I am troubled by the notion that most of the acreage in the proposed unit is owned by Noble. And we've got a similar matter tomorrow. In fact, with even more skewed percentages. And so what I'm troubled by in this whole thing is what's the principle we're applying here? Is it that there's some percentage interest? Is it a majority interest? When is it that an application for a DSU shouldn't be granted by this commission because the party filing the application doesn't own enough interest? I don't know what that principle is or what rule we would be applying. And so I am not sure why we would be denying an application to develop reserves or a resource that otherwise is going to stay in the ground. I'm concerned about the 3 wells and the fact that they might be damaged, but there are a variety of ways to handle that. In my dialogue with Ms. Jost, I alluded, I think, to some, which would be in the permitting process. I would expect there to be conditions of approval that would require adequate distance. I think maybe you could even require compensation. I think the parties could, if Noble were so inclined, negotiate a joint operating agreement to get these wells drilled and and provide for appropriate compensation to Noble if in fact the wells are adversely affected. But I still come back to the fact that you've got these diagonal wells and probably in a number of other places in the basin that are sitting out there, as somebody said, I think maybe it was Ms. Lima, in the early days, that's the way the development was done. Now, for a variety of reasons, it's not, but they're sitting there. So you've got to deal with them. Maybe there will be some damage. But does that mean you don't further develop the resource in the areas where those wells are situated? I can't get there. So if it weren't for the inclusion of the west half of 24, this would be, for me, a fairly straightforward, fairly easy situation. Including that acreage does bother me for the reasons that have been expressed. Ironically, including it, of course, increases Bonanza Creek's percentage ownership, which makes it look better. But as has been said, it includes mineral owners participating in production from these wells who wouldn't really be contributing much, if any, actual value. to these wells. So that does trouble me. I would be searching for a way to convert this to a 960, which I know wouldn't satisfy Noble. It might be marginally more acceptable to Noble just because they're not as diluted, but they're still in some ways more diluted because they would own a much higher interest in that proposed unit. But that's not the application before us. So I think where I finally come out is I would grant the application. It's the spacing unit stage. There's a lot yet to come on this. And I would rely on the permitting stage and the pooling stage to deal with a lot of the issues that have been addressed.
Thanks. Commissioner Jolly.
Well, I'm concerned about the west half of 24 also, but I haven't seen any pushback from the mineral owners of 24, and I would think they'd be here at the west half if they had significant concern other than Noble. But the fact that there are no protestants that own a mineral right, maybe they know they're going to do better with this overall plan. I don't know. But in fact, it should be a 960, I think, but it's not what was presented. And maybe it'll even out over the project. I don't think historically we haven't had a minimum percentage. So I don't think we can just that would be really precedent changing to rule that way right out of all of a sudden. So the diagonal wells also, are probably inefficient. They're holding a lot of acreage kind of hostage there. 20, whatever the amount will be, horizontal wells will more than make up for replacing those, I believe, and recover the same resources. And we have an operator, I think, that's ready, willing, and able and active in that area that wants to go drill it. And another one that it's hard to figure out where their priorities are. They've got an awful lot of irons in the fire out there. So I reluctantly am leaning towards to supporting this.
So a couple of things. We have approved spacing units at very low interest a couple of times. So there is no bar at which we say, well, below this amount, you wouldn't approve it.
I think that's what I meant.
And it's mostly tied to, do you have someone who's out there willing to put forward a plan to develop it, risk the capital? Here you have an issue that they're going to, relatively is that Bonanza Creek, if they're risking whatever their capital is, that's $17 million what was spread out that. How does that compare to $40 million out of $1 billion company's case? I think it's tough to come down to that, and it really comes back to that definition of correlative rights. Is that each owner shall have an equal opportunity to obtain and produce their just and equitable share. We have to decide, is this spacing unit going to allow the folks in section 25 to obtain their just and equitable share of the minerals underneath that? And if this was, I think every commissioner said, if this was a 960, it'd be no problem. It's just that you're dealing with it. There's not much left. Those 3 wells, as you said, there's 270,000 barrels equivalent at most. It's quite likely that horizontal development plan will capture that. And even if those wells do get plugged out. And so. Yes.
Yeah, thank you, Mr. Chairman. For my first meeting, I just want to recognize both sides of this discussion. I think you all did an amazing job of presenting and the information. I have a lot of notes how I could argue both sides very well. And it's almost like you need a one-handed economist, right? That tells you, okay, where's the economy going? Because you have this side and that side, and you all did a phenomenal job. And appreciate everyone's comments here. I agree with a lot of what has been said. But for me, I'd say right now I'm leaning towards supporting this in part because you have the centralized production facility right there. You already have like infrastructure in place. You have I guess that's right next door in section 26. And I think big picture, this development plan could be better for the environment because you already have the infrastructure just right there. But I also share a lot of the concerns that have already been raised. So that's kind of my thoughts right now.
All right. Any more comments?
May I just,
Commissioner Overturf.
just wanted to react to a few things that Commissioner Boygan said, which is that I want to make it really clear that I'm not proposing that we adopt a minimum percentage sort of standard for granting a spacing order like this. I recognize that there's not a standard like that in the statute. And so if we were going to do something like that, we would need to do it in a rulemaking and not in a proceeding like this. And then the other, just in regard to your point that that the resource, if we leave things sort of the status quo and allow Noble to continue with its existing development in section 25, that is going to lead to part of the resource not being developed or leaving it in the ground, that my understanding is that Noble's business model is not to leave things, to keep it in the ground. I mean, they have an incentive. Their business is to take the resource out of the ground. It's just that the technology that they're using to do it is technology that's 8 years old. Is it the same caliber of what we would see today? No, not necessarily. But to me, it seems akin to having an iPhone that works perfectly well that you've had for 5 years and versus trading it in for the next one as soon as the next model becomes available. That there's value in continuing to if that technology is still functional, let's let it play out, and then we'll see if there's an economic path forward for further development. So, but I mostly just wanted to clarify that I'm not proposing that we establish a minimum ownership percentage requirement.
Commissioner Boygan.
I always appreciate Commissioner Overturf's reasoning. It's always given me lots of food for thought. And I think I would only respond on the point about the iPhone. To me, it's kind of the flip phone versus the iPhone. It's drilling diagonal wells under old technology that are now in fairly steep periods of decline, and they're spaced pretty far apart versus drilling modern horizontal wells pretty close together in a number of laterals in that section, which will capture a number of reserves, which Noble could do. Noble, no doubt, could do it. Noble's great at it. Noble has other priorities. This is not a core area for them. Obviously, when you look at the map, it's a core area for Bonanza Creek, not for Noble. That's not Noble's fault. There's nothing wrong with that. It's just that they don't have any they've got a lot of other priorities, as has already been said. So I believe that the Bonanza Creek DSU would, in fact, produce additional reserves than will be captured under the current development that's out there. Whether Noble, in fact, would go out there a year or 2 or 3 years from now and drill 1 mile laterals, or maybe even put their own 960 together, they might, but we don't know. Mm-hmm. So that's where I am on it.
And waiting longer potentially creates additional waste because those wells continue to have pressure depletion in that section. So the horizontal wells drilled today may end up with better overall average performance compared to ones drilled 3 or 4 years from now. And it's something we do have to consider as well. So. Any other comments?
I have a question.
Yes, Commissioner Egger.
This is for Commissioner Boygan. You indicated, and you had some back and forth with Mrs. Jost about where this could be taken up later in the pooling or in the Form 2A. Can you explain what that might look like if we approve the application?
Really good question, Commissioner Agar. I'm expecting a free-for-all unless Noble and Bonanza Creek can actually get together and negotiate something, which I'm hoping they'll do. Bonanza Creek's going to have to file a pooling application here because they can't obviously penetrate Noble's acreage without getting it pooled. And that means they need to make a reasonable offer. And so there's obviously opportunity there to negotiate, but also to differ. Noble could decide to participate under terms that they negotiate. Noble could decide to sell and just be out of it. So there's a variety of ways that could play out. But ultimately, Bonanza Creek presumably would seek to pool and possibly to force pool. And it could come up to us if they can't get together on that. And then in the permitting process, I gather there are already Form 2s that have been filed. I'm not sure if they've been approved. So there can be conditions of approval requested and granted on those Form 2s to protect these existing wells. Not sure exactly what those would say, but there's opportunity there to deal with that issue. And I think staff has certainly heard all of us on that point. So there are stages yet to come in this process where the parties can work through it and come to some kind of resolution that they can all live with, or they can continue to fight, I guess.
Thank you.
Have we exhausted all our comments and are we ready to someone to put forth a motion? Okay, Commissioner Boygan?
I'll move that we approve the application as filed.
Mr. Boygan has made a motion to approve the application as filed by Bonanza Creek. Is there a second?
I'd second it.
Seconded by Commissioner Jolly. Is there discussion? Additional discussion?
I have one comment.
Yes,
I'm going to change I'm just going to explain why I'm going to change my original thoughts. And I've been persuaded by some of my my fellow commissioners, mostly about having the surface infrastructure in place, and then having some potential options for Noble in the future.
Very well. Any additional discussion? Sounds like we're ready to vote. Ms. Larson, it probably would be a good idea to do a roll call.
Of course. Chair Benton.
Yes.
Vice Chair Boygan.
Yes.
Commissioner Ager.
Yes.
Commissioner Gibbs.
Yes.
Commissioner Hawkins.
No.
Commissioner Jolly.
Yes.
Commissioner Overturf.
No.
5 in favor, 2 against. The motion carries.
Well, the motion carries. Thank you all.
Thank you.
Thank you.
Good night.
Thank you.
Difficult, you all did a great job.
No doubt.
I think we're adjourning until tomorrow. We need a motion to adjourn until 9 o'clock tomorrow morning.
So move.
Motion made by Commissioner Boygan, seconded by Commissioner Hawkins. All in favor, say aye. Aye. We'll see you tomorrow morning.